It was appearing in the list.
Monthly list.
Monthly list.
For application for registration, within time it is filed.
Item number 315 of today's case. Last day for accommodation after 27 this month.
Mention that in the slip, hand over the slip. Yes.
Your Lordship,
My lord, I'm seeking leave before lordship to file this matter without the certified copies and also for
Why?
urgent hearing. My lord, the issue is that it's a SEBI matter, and once we went to the department to apply for certified copies, the certified copies are unable. However, they have given us a server copy.
Server copy is available.
Yes, lordship.
Same period, server copy. 13th order passed. Server copy.
Civil court's order.
Great.
So you have applied for the certified copy. You have annexed the slip.
Yes, it is with me. If you're not, once I can produce this.
Xerox copy of that slip and then.
Your Lordship, if I'm permitted.
Sir, what is the grave urgency that it cannot?
13th of the order passed. Received application was allowed.
What application?
Received application allowed.
Yes.
In terms of certain
Receiver
plots,
application allow.
certain plots of that. Subsequently, it was detected 2 plots have been excluded from the deed of the receiver. Application filed for incorporation of those 2 plots. That was rejected.
Your Lordship, if I'm permitted to mention one matter, the matter was heard by his Justice, the Lordship Rajabhuri Chaudhuri, and he had directed for the production of the minor child. He wanted to speak with the minor child personally. The problem is, Your Lordship, the minor child has to be brought from Bangalore. So, if Your Lordship wants to speak with the minor child, kindly keep it under the heading to be mentioned tomorrow.
Let it appear, thereafter I will consider. Yes.
Two very urgent application, Your Lordship, appearing in Your Lordship's list. 380. Yes. Motion 380 and 382.
What is the nature of the application?
My Lord, it's a revision. We had challenged the order passed by the Ranit.
Yes, sir, it is appearing under the motion. Why you are saying application? That is why.
No, it's motion
380 and
382.
what is the urgent? What do you want?
My Lord, date has been fixed for delivery of possession. Wherein Your Lordship, that
When is the date fixed for delivery of possession?
3rd of March 2025 in both the matters.
3rd of March. Mention that, hand over only those.
I'm giving the order also. I'm annexing the copy of the order.
Mention the date when the date has been fixed for delivery of possession. Mention that in the mentioning slip. Hand over the slips. Only those matters where delivery of possession has been fixed.
Item number 61 of the bill list.
Yes.
Emergency is there because the state not said by the Justice Tribunal. The official of
61 is fairly at the top. It cannot be upgraded.
My Lord,
Yes.
my Lord, one section 7 and 7.2 application, my Lord, administrative delay, section 5 filed on section 7172, my Lord, and it is pending since 16 years, my Lord.
Expeditious hearing, no urgency.
My
Yes.
Lord, my Lord, kindly appreciate, my Lord, section 5 in 7127 pending since 16 years, my Lord.
Expeditious hearing, no urgency. It will be taken up in due course. Yes.
With respect to Millard and matter Millard, where Millard I have mentioned day before yesterday, item number 54.
Item number?
Item number 54, day before yesterday.
Yes.
Millard to be placed today, Millard I prayed for 1 day's adjournment to obtain the cross-examination if Millard recalls. Millard,
Yes.
that matter has not appeared in the list today. Millard, tomorrow is the date of argument.
What is the date of argument?
Tomorrow.
Tomorrow, mention that. Tomorrow ta diye deben.
extension of
When it is expiring? 21st of February. Have you mentioned the date? Expeditious, no urgency. Yes.
My lords, item 1330 of the monthly list, it was set to made returnable on 20th January. The urgency is my visitation rights to my minor daughter has been denied. This is the short point. If it could be included in the daily list anyway.
Hand over the slip, yes.
3 matters, my lord, where I was the defendant. The issue has been settled between the parties. The plaintiff has filed a 23-3 order 23 rule 3
What do you
application.
want?
My lord, for consideration, because for the last 1.5 years,
Matter is appearing in the list.
it is not, my lord. My lord had directed it to come on 18th of February, but my
Yes.
lord, due to change of determination, it is not appearing.
All right, hand over the slip.
No, may I Lordship kindly to mention a matter for expeditious disposal, matter item number 230. It is in respect of an application for alimony. My client had not received a single penny for the last 5 years.
Expeditious hearing, no urgency.
No, no,
Cooperation.
No, it is for alimony, my lord. 5 years here, she has not received a single penny, my lord. Can I kindly appreciate?
What is the date fixed for?
My lord,
hearing?
it is fixed on 25th of March.
In the learned court,
Yes, yes.
trial judge.
Yes.
Or let the monthly list be published thereafter.
Fine,
mentioned.
like item number 230, my lord.
Please,
It will
please.
take 1 minute, my lord. I kindly appreciate.
All matters
The
for you, it
expeditious-
will take 1 minute, not
the
for the court.
expeditious disposal in respect of an application for alimony, my lord.
Wait. Yes.
May I mention this matter just for introduction matter? For starting with the list of 5, applicant record. Item number 687 of the monthly list, my lord.
For upgradation,
Yes, my lord, my,
mention the urgency, hand over the slip. All right, hand over the slip.
it's the law, which is 25th of April.
Yes.
Madam, may I be permitted to mention a matter?
For argument, have you mentioned that?
And if I have not mentioned, I have.
Mention that. What is the impugned order?
Order 6 rule 9 application has been rejected.
Order 6 rule.
9 application, but I have rejected.
My lord,
ওটা দিয়ে দেবেন কালকে 25th আছে বোধহয় আর্গুমেন্টে যেটা ফিক্সড আছে
my lord, may I be permitted to mention a matter for expeditious disposal, my lord?
expeditious disposal, madam, there is no urgency, matters may be taken up in due course. Yes,
My lord, may I permitted to mention one matter, which is lying on court number 5. It is in
hand over
running.
the slip. Yes, Mr. Haldar,
Extension of interim order, my lord.
when it is expiring,
My lord, it has expired. I took out an application for extension of interim order. It is, my lord, with the file. My lord, file in lying in code number 5. Another is, my lord, this matter was, my lord, was a new motion. The matter was heard. Subsequently, it was directed to be heard on 18, but it has not been appeared. That was directed by Honorable Justice.
hand over the slip. Yes,
File lying.
yes.
My lord, this is for an expeditious matter. One order of Justice, Honorable Justice Shampar Sarkar was there, and it was directed.
What do you want? Expeditious hearing?
Yes, your
It will appear in due course.
lordship.
Yes, call the list.
My lord, for inclusion only. Shall I submit the same for inclusion?
Let the list be published. All the files have not come, sir. Please wait.
My lord, this file is lying in court number 5, your lordship, but not included.
That has not come yet. Let the files come. Please wait for some time. It will appear.
No, my lord, this file it's not included in any of the courts, your lordship. That's the problem.
It is not appearing. It was not appearing in the list.
No, your lordship.
It was not heard once.
No, your lordship.
When have you filed that?
It was filed in August 2024.
It did not appear after that.
No, my lord.
And what the slip? Mention that it did not appear once.
Much obliged.
Mention that in the mention slip. All right, hand over the slip. Yes, call the list.
Inclusion of urgency.
Urgency you have mentioned.
Yes.
Yes, call the list.
My lord, it's a partition suit, ex parte. Order 6 Rule 17 was filed. That is at the time of preliminary decree passed. At the time of conducting the commission work, commissioner found that in the schedule of the plaintiff, actual measurement is less than what is the actual measurement.
What do you want?
Upgradation, my lord. Item number 932.
Yes, call the list. You are appearing.
Yes, madam.
It is
Defendant,
an assigned matter.
yes, because while the order passed by the learned.
All right, so is there any caveat?
No, no caveat.
When do you want? Next week?
But as early as possible, because the suit is continuing, we want to.
ওগুলো হিয়ারিং এটা একটা মোশনে করে দিন মানডে আন্ডার দি হেডিং আচ্ছা অর্ডার রেকর্ড করে দিন দিস ইজ অ্যান অ্যাসাইন্ড ম্যাটার ফার্স্ট অফ দ্য লার্নেড অ্যাডভোকেট ফর দ্য পিটিশনার ইজ প্রেজেন্ট লিস্ট দিস ম্যাটার আন্ডার দি হেডিং অ্যাসাইন্ড ম্যাটার অন মানডের কত ডেট 24th yes next
That debts recovery tribunal, that debts recovery tribunal.
you have supplied him the
Yes,
judgments in which you appeared.
No, in,
You have not supplied that judgment
no.
in which you appeared.
But, I have
This is
supplied him.
Sumi Dasgupta versus Bank of Baroda.
Yes, yes.
So there it was extensively considered all the judgments. That judgment you have not brought.
But I have supplied him judgments from 1969, where the exceptions were carved out for the
Yes,
first
sir.
time. But I have explained him. I had called him, but he happened to be my chamber junior at one time. So I called him yesterday evening. I have
Yes,
explained
what
him.
do you want to say?
My lord, actually, my the counsel, my friend, who will appear and present this matter, he has some personal difficulties. That is why he cannot come right
What
now.
date to be fixed?
No, sir. If it is fixed tomorrow, it would be fine. And if not possible, kindly fix the matter by at 12:30.
Tomorrow Mr. Datta, tomorrow? You have difficulty?
No, my lord, as your lordship pleases.
Actually, his father suddenly got sick today morning.
Then it's better tomorrow because may not be available at this. Ashwin,
Yes, my lord.
the learned advocate appearing for the petitioner prays for an accommodation on the ground of his learned senior, full stop, as prayed for by the learned advocate for the petitioner, list this matter tomorrow under the heading
To be mentioned.
listed motion.
To be mentioned. To be mentioned. And this is appearing as to be mentioned.
To be mentioned for a different purpose. Now he says that his senior wants to argue. That is, he says that he wants to argue. If it wants to argue, then
Oblige,
he has
my
to be
lord.
given a chance to distinguish or to make his submissions.
And it.
Yes.
Yeah, item number 3, I am for the opposite party.
These applications for the extension of extension from interim on lordship, and this is the affidavit of service lordship, and the
Section 24.
yes, lordship.
From where to where?
Lordship,
From Barakpur.
From Barakpur to Ranaghat, my lord.
yes, lordship.
My lord, I need some instructions. My lord,
What instruction?
my lord, it's 2023 matter, my lord. Thereafter, there are certain developments, but the learned advocate conducting before the court below, my lord, he met an accident. My lord, for that reason, my lord, I could not gather the information, my lord.
Your
And-
suit has been stayed.
Yes, my lord.
So then have to extend the.
No, my lord. What happened, my lord? In the main applications, my lord, they have stated the another application which was transferred, but that order was not communicated before the learned court below. My lord, the transferor court. My lord, as a result of which, in that court, my lord, already the order was the application was disposed of. My lord, for that reasons, my lord, I need some instructions with regard to the.
When can you come back?
My lord, on Monday, my lord, and keep
Monday.
Monday.
When the interim order expired?
My lord, already
Lordship,
expired.
already.
After expiry of
When?
Lordship,
September 2024.
once
my lord, it's June.
June 2020.
My lord, after expiry of the application, interim
So
order, my lord,
September 30, 2024.
September 30, 2024.
So you have filed the application also in December. So
yes,
after
my lord,
that.
after expiry.
What is the next date fixed in the suit?
That I have to take instruction.
All right, Korun. On the prayer of the learned advocate for the opposite party, list this matter on Monday করে দিন, under the same heading.
Kindly lordship, will stay for Monday.
No.
Kind lordship.
Be ready with the main matter.
Yes.
Be ready with the main
But,
matter Monday.
Till the lordship is the Monday, lordship. Kindly stay till Monday, lordship.
It is fixed before Monday in the trial court.
Lordship, this is not instruction from me.
Take instructions. If you have instructions that it is fixed prior to Monday, come and mention. You have filed this affidavit service today.
Yes, lordship.
Every service filed in court today is taken on record. Take instructions. If the date is fixed prior to Monday, mention. After giving notice to him. Yes, next.
Item number 4, I'm for the applicant.
Yes,
This is also the
file नहीं
extension of interim order, lordship.
not in the file.
And this is an affidavit, lordship.
And application has not yet appeared, has not yet come. So can 1 of 2024?
No, lordship. Can 2, lordship.
Can 2 is not available with the record. Who is appearing for the other side?
If
This is also section 24.
no, lordship. I'm challenging the district commercial state commercial dispute redressal commission.
State.
I'm challenging the
So, appeal lies before the National Commission.
Yes, but there is a specific instruction that the appeal file before this state authority. So there is a delay, 15 days delay. But in the application, the state consumer redressal tribunal not considered the 15 days delay, Lordship. And therefore, the Honorable Court stay over this order.
Every service filed in court today is taken on record. तो application টা তো নেই। You have a copy of the application.
This is my copy.
Give a Xerox copy of that. Make a Xerox photocopy and file it in course of this day. It is pointed out that Can 2 of 2024 is not available with the records. So stop. The learned advocate on record of the petitioner is directed to file a photocopy of the said application, which shall be treated to be original till the original is pressed out. Full stop. The department is directed to trace out the original application and place the same and tag the same along with the records of this case. ঠিক আছে, এই লাইনটা না আগে লিখবেন, তারপরে হচ্ছে photocopy treated to be original till the original. Next, this is an application for extension of interim order. First up, affidavit service filed in court today is taken on record. It has been submitted by the learned advocate for the petitioner that the application has been duly served upon the opposite parties. Opposite parties or opposite party? Opposite parties you have served, both the opposite parties. Yes. Opposite parties. First up, it appears from the record that the interim order was initially passed on December 9, 2023, and the same was extended subsequently till November 30, 2024, or until further orders, whichever is earlier. First up, this application was filed on 27th of November 2024, that is prior to expiry of the interim order. First up, in view thereof, the interim order which was initially passed and extended subsequently is further extended till the end of June 2025 or until further orders, whichever is earlier. List this matter under the heading contested application in the monthly list of June 2025. Next.
I appear for the opposite party. I have taken out an application for vacating of the interim order. This is a very serious matter, my lord. This is an order passed by the learned maintenance tribunal. But my clients are the
Who
unfortunate.
is appearing for the petitioner in the civil division application?
I am-
You are appearing?
Yes.
Yes.
My lord, if I may say, my lord, 2 points, very important point, my lord. There are 2 aspects.
You want vacating the interim order. So
I'm
the main matter is to be heard out.
Yes, my lord, I'm ready with the matter because the point is very simple, my lord.
Yes, are you ready with the main matter?
Lordship, yes, Lordship, I am ready. Lordship, in this,
Are you ready with the main matter? Yes or no?
Lordship, in this matter, my senior is appointed, but I'm just
Who is
filling the
your senior?
Mr. Shivaji Kumar Das, Lordship. Mr. Shivaji Kumar Das.
Tomorrow, under the heading motion.
Lordship, there is a specific direction. The eviction order was passed by the
Yes,
subdivision
yes.
officer,
The
Lordship.
main matter, you don't want the main matter to be hard.
There is two more.
Then there is something in it.
Obviously, my lord, criminal cases lodged by the
Main matter
son
will be
against the
decided
parents.
once for all. Why do you only want extension of interim order?
My
Criminal
senior
cases
has
lodged
no
by the
instructed to
son.
me, Lordship.
For
That's
extending.
only for extension.
Kindly understand my predicament. I am an old age citizen. Criminal cases lodged by my son. Twice, not only once, against me.
Come tomorrow. Ask your senior to come.
My lord, I'll answer, my lord. There is one question of law that is to be decided. My lord, the issue is here. He has challenged the propriety of the order. He says that under section 23 of the Act, the learned tribunal cannot
Where is
pass
the impugned order?
the last page of my lord, his application. First of all, my lord, he has not preferred an application under 226. Although this is a quasi judicial authority. My lord, be that may, I am not taking that point. My lord, this 227, the scope is widened. Now, my lord, kindly looks into the nature of the order.
I took that point and I lost.
Yes, I have considered the judgments today morning only. Because the 227, my lord, this Bantia judgment, my lord, I am carrying that. My lord,
So
yes.
I took a similar point
Yes.
which you are now taking today.
Yes, but I am not.
When I
pressing-
was there, I took that point.
I am not
But
pressing
I
that.
lost.
I am not pressing that because my good point is, my lord, that the conduct. And my lord, the second question is whether under section 23 of the Act, the tribunal can pass an order of eviction or not. That's the question before this court.
Eviction.
Yes. Supreme Court has held that.
Lordship, I'm challenging.
So where
the
is that order?
jurisdiction of
What is
this
the order, date of
Lordship.
the order?
The date of the order 26/2022. That's the last page, my lord.
Where is the application?
Yes, Lordship.
Where is the application under section 23?
I just check up, my lord. I don't know whether he is annexed. Application to annex করেছে? No, I don't think it has been annexed. Complaint?
It was filed under section 23 of the Senior Citizen Act.
Lord, it was filed under the Senior Citizens Act. Now, under section 23,
Yes.
the issue is
23 provides for cancellation of the deed of gift.
No, there are two aspects. Well, there are two aspects. I'll cite those judgments. One is with regard to cancellation and transfer of possession. Now, interpretation of section 23 says for granting protection, if it is required, then, my lord, the court may or, my lord, the tribunal may direct for eviction. Because here, the son and the daughter-in-law has lost two criminal cases against the father and the mother. One has been quashed, one is pending.
Lordship,
To secure their possession, now
the
they go
Lordship
for the
kindly
trial
see that my application,
and
Lordship,
they
kindly
have to
see
be
my
the
page
tenant.
number.
The learned advocate appealing for the opposite parties in the civil revision application submits that he has taken out an application being, what is the application number?
So the application number is
1 of 2024.
Lord, can 2.
Can 2 ta kothay?
Can-
হ্যাঁ। That he has
Can
taken out an
1, Lordship.
application.
Sorry, I said
Can 1, Lordship.
No, no, no,
Can
can
two
2 is for vacating.
can 2 can. Can 1 to tomar hobe.
Can 1.
With deepest of respect,
Can-
my lord, his
Can
extension
2 of
application has not
2024
been served.
for
His extension application has also not been served.
No, no, Lordship, I'm served
of
my
2024
Lordship.
for vacating the interim order. So stop. Which application is for extension of interim order?
Lordship, can number 1, Lordship.
1. Have you served?
Yes, Lordship, I have filed my affidavit of service, Lordship.
You serve him an extra copy, sir, since he is disputing.
My specific instructions not been
Just
served.
serve him a
Because what happens, the son and
he further submits
parents
that
stay in the same.
Now,
the
Lordship, I am
petitioner
handing over
in the
to
civil revision application
Service
has
দেখাবে?
not.
জমা দিয়ে দিন।
Sir, can you not serve an extra copy? You need not show.
Yes, sir.
কি হলো? Has not been, has the learned advocate for the opposite party submits that the petitioner in the civil revision application has not yet served a copy of the extension of.
Now it has been served, Lord.
Let it-
This
let
is
it-
not something I.
Shed.
Only thing tomorrow hears out the application.
Since an application has been taken out for vacating the interim order, this court is of the considered view that the main civil revision application is to be taken up for hearing. First up, list this matter on Monday, under the heading motion. Yes. Monday date ta diye debe na.
Well, 10:30.
Let it appear.
Lordship, under the heading motion, Lordship, under the
Only
heading
thing is that
application,
for
Lordship,
2 years I am
under
suffering.
the heading application, Lordship.
Why application?
Why? Main
He
matter
wants
of,
to drag the matter. Not, I'll tell what has happened.
then I will not extend the interim order. Yes, next.
And 6, Lordship, I am
Lordship has extended it till Monday.
No, I have not extended. Matter will appear.
Yes, grateful to your Lordship.
The main matter will
Then
be hard.
the
That is
file
the
will go
direction.
on. The file will go.
My lord, item number 6, my lord, I am for the respondent.
You are for the opposite party.
My lord, kindly take the matter tomorrow, my lord. Kindly
Lordship.
take the matter tomorrow. Mr. Shukla
Tomorrow.
is appearing in this matter.
This is the Lordship.
Personal difficulty.
Interim order is subsisting. It has expired.
Lordship.
My lord, order expired on November.
Till the end of October.
Yes, Lordship.
So it has expired.
Expired
So
already.
tomorrow.
My lord, a copy of the application has not been served upon.
Sir,
us.
please serve a copy of the application.
Lordship already served.
My lord,
One extra copy is photocopy.
Good.
Why are you quarreling with these matters? I have served. Give a photocopy.
Good.
Yes, not today. Next.
Good. 7, I'm appealing for the petition. I'm praying for 1 day's accommodation only because
Why?
I've just been briefed today. Yes, I've just been briefed today morning, Your Lordship. I have not been prepared yet.
1 day.
Sir, only 1 day accommodation. This is a section 24 application, Your Lordship. I need to get some time for preparation.
Section 24 transfer.
Yes, Your Lordship. I need some time to get prepared. This matter, Your Lordship. Kindly keep it tomorrow, Your Lordship. I shall apprise the court.
An accommodation has been paid for by the learned advocate for the petitioner. To stop. Hearing of the matter stands adjourned for the day. Next.
Your Lordship, I am appearing for the petition in this matter, Your Lordship.
Yes.
Your Lordship, in this matter, the petitioner is seeking transfer of the matrimonial suit which has been filed in, Your Lordship, in Chichura Court, Your Lordship.
What is the stage of the suit?
Your Lordship, it is in preliminary stage.
This is that we had entered appearance on 14th of January, wherein directions for written statement had been filed. The order is annexed at page 30.
You have filed your written statement.
Your Lordship, today was the date fixed for filing of the written statement, 19th of February, page 36, internal page 2, order number 3, dated 14 January 2025. They had moved the application without serving us, Your Lordship. But through
Which application was moved without serving you?
Your Lordship, the divorce petition, we filed our applications.
Divorce petition, after filing it is served. It's
Your
not the
Lordship,
other way around.
Your Lordship, that was at page 16 is our adjournment application, which we had filed on 14th of January, wherein we had stated that we did not receive the copy of the plaint, and we asked for the copy of the plaint, and so that we could file our written statement, page 16. So it was, they were trying to move ex parte, Your Lordship. Thereafter,
What they were trying to move ex parte?
the respondent, my husband, was
How do you say they were trying to move
because
ex
the
parte?
plaint was not served upon us, Your Lordship.
The by the order dated 17th of February 2024, there was a direction
Your
for
Lordship,
service of summons
Your Lordship,
through both ways.
Your Lordship,
And the date was fixed on 14th of January.
Your Lordship.
So on that date itself, you have appeared.
Your Lordship, on 4, but we were not
You have appeared. How did you come to know about this proceeding?
because we were doing a searching online, which I had stated in my petition and I had also written. I obtained the certified copy of the plaint. Thereafter, I got the plaint.
You could have said, because have you pointed out, have you alleged that there was no non-compliance of the order
Page
dated?
16, Your Lordship, I had filed my petition.
Have you alleged that there was no non-compliance of the order dated 17th of December 2024?
Your Lordship, page 16, I had filed the application before the
16.
1/6 before the district magistrate, para 2,
Magistrate.
district judge, third court at Chinchura.
So you are saying district magistrate?
That the above named respondent has not received the copy of the plaint that the learned court.
That is a different thing. You have not received. I'm asking you non-compliance. He may have complied with the directions,
Your Lordship,
but he
maybe
may not have received.
it.
So there is nothing
Your
wrong
Lordship,
with the petitioner.
Lordship.
So that is why I asked you, I put the question to you. Have you alleged non-compliance of that order? You said you have filed that petition.
Your Lordship, my prayer over here is that the petition may be transferred to either Alipur court or Bansal court, or because it is filed in Chinchura court. We were married.
Where are you residing?
Your Lordship, I am residing at Chinar Park in Chinar Park at Airport, Kolkata. Your Lordship, Para 11 I have pleaded. And we were residing at
That it does not take much time.
Your Lordship, my
to-
parents are
That is a different thing.
ill. I
Does
have
not take
annexed
much
the,
time to attend.
Your Lordship, I have annexed the medical documents of my parents, which is at page 17 onwards.
What
Your
are you
Lordship.
doing?
I am working in an IT company, Your Lordship.
Have you stated that in your application?
Your Lordship, I have not filed any application for maintenance or anything, Your Lordship.
I'm asking you, have you stated that fact in the application under section 24?
Your Lordship, I have stated that I am working and taking care of the parents. It would be
No.
difficult for me.
Working where? Please file a supplementary affidavit stating in details under which company you are working, what is your place of office, how do you attend office?
Your Lordship, Para 16, I have stated that the petitioner wife is permanently residing at Itna. It is quite
Maybe you are
important.
residing, but you are working.
Your Lordship,
What is your-
matrimonial suit by taking leave from her job with which she is maintaining her. I have stated that I am in job and I do not require any maintenance, Your Lordship. That may be recorded.
Madam, maintenance is a different thing altogether. I'm asking you which company you are
Your Lordship.
employed, where is your place of office, how
Your
far
Lordship,
it is
the
from your
IT
residence,
department-
how do you attend the office? All these facts may be relevant for
Your
the purpose of deciding this
Your Lordship,
application.
I'll do.
Ashwin, on a query of the court, the learned advocate appearing for the petitioner submits that the petitioner is working in an IT company. First up, such fact.
Your Lordship, I do not know IT company. She is working. That I know.
She is working. First up, the petitioner is directed to file a supplementary affidavit stating in details where she is working and the place of his office. Let the supplementary affidavit be filed
Within a fortnight, Your Lordship. I'll do.
within a fortnight from date. List this matter in the monthly list of March 2025.
Your Lordship, meantime, may I serve the supplementary and this copy upon
First file the supplementary, thereafter you will serve. Maybe you may not require to serve.
Your Lordship,
Let me see the supplementary affidavit.
because the court will not grant further time to file it. Today is the date
File.
fixed.
Madam, you file your written
Your Lordship.
statement. Because prima facie, if you are working lady, you are in a IT
Your Lordship,
company.
IT company, all of them are working from home only. They have that, they don't go to office.
But you will not go to office if your employer wants.
Your Lordship, no cause of
Madam.
action has arisen in Chichura, Your Lordship,
Maybe.
because he is also residing in Bangalore. He was residing in Mexico. He was posted in foreign. He's not residing in Chinchura. What has
He
been
is deciding.
He's residing in Bangalore, which I have stated. Our matrimonial home was also in Bangalore.
Court and text transfers it to Bangalore.
Your Lordship,
Don't
but
make those submissions.
marriage was, everything was solemnized
Because
in
we are online.
airport.
Online, maybe someone is watching. So don't make those submissions. It's better you file a supplementary affidavit. Thereafter, I will consider, I will direct you.
Your
Sir. Yes, next. Huh? Section 24. Section 24. Motion. Yes, next.
Beg to appear on behalf of the plaintiff, respondent, petitioner before your lordship.
Plaintiff respondent, so it's against injunction, miscellaneous appeal, thereafter civil division.
Appeal court, my lord, appeal-
Injunction application, miscellaneous
yes,
appeal,
yes.
thereafter civil division. Yes.
Lord, your lordship will find, but this is suit for partition and separate possession. And alternatively, demarcation of the property purchased by the plaintiff and the defendant. Originally, my lord, the Jogesh and Jagadish, two names, your lordship kindly have a look to. Two names, my lord. Both of them purchased, my lord, a piece of land, measured 85 decimal, my lord. And
What is the injunction you have paid for?
My lord, first time injunction was granted on, my lord, first time on 9th July 2021, page 30 of the application, your lordship kindly have a look to.
Page?
Page 30.
Yes.
This is the order passed by the learned trial court regarding an interim injunction application, and at that time, my lord, an interim order maintaining status quo was passed, my lord. And the defendant number 1 and 2 was directed not to make any further construction over the suit property.
Yes.
After contested hearing, my lord, your lordship kindly have a look to the final order. Your lordship kindly have it to page.
What is the date of the order? 31st of July 2023.
My lord.
Certified copy is there.
That was the order passed by the learned appeal court, my lord, page after page 81, your lordship kindly. After page designation page 81, thereafter.
Yes. Yes.
My lord, that is my lord, order dated 31st July 2023.
Yes.
My lord, herein, my lord, the honorable trial court, my lord, page, next page, my last page, your lordship, ordering portion I am placing before your lordship.
Status quo order was passed.
Yes.
Yes.
Well, this was confirmed, my lord, which was passed earlier. And that has been confirmed here, my lord, till the disposal of the suit.
Yes.
My lord, the opposite party here in, my lord, filed an application under order 7, rule 11 of the Code of Civil Procedure, and that was, my lord, dismissed. No appeal against that. But appeal court found that suit is not maintainable.
Suit is not maintainable.
Not maintainable. In passed by the London appeal court, suit is not maintainable, and it was, my lord, application was allowed. I am placing the exact portion to your lordship, my lord. Where your lordship kindly have a look to page 14, 19, my lord, 19.
Page 19.
My lord. Top, my lord, page 19, top.
Certified copy.
Yes.
It is settled law that self-acquired property is excluded from partition. It is submitted, it is admitted fact.
Place from page 17.
My lord, my lord, my lord, I am coming to. Yes.
Last paragraph, the main contention of the plaintiff.
The main contention of the plaintiff respondent is that property between Jogesh Chandra Samant and Jagadish Chandra Samant was not partitioned by meets and bounds. Meets means.
Thereafter, you can skip 2-3 lines because partition, meets and bounds has been defined next.
My lord, person, family member, so that each of person gets his or her property and becomes
property of Jogesh, nearing the middle of the next page. The property of Jogesh Chandra Samanto and Jagadish Chandra Samanto. You have not got page 18, first paragraph nearing the middle.
Yes. Yes, it is the finding, my lord, from top to below first paragraph below last portion. At the best, phrase demarcation by measurement can be made if anyone of the
prior to that, 2-3 lines prior to that,
there is
property
no
of Jogesh Chandra Samanto.
Yes.
Place that.
The property of Jogesh Chandra Samanto from this property of Jogesh Chandra Samanto and Jagadish Chandra Samanto, if any one of the two is occupying more area, the suit for partition may be maintainable among the legal heir of Jogesh Chandra Samanto if the share devolved upon them from their father, if anything left, and if not partitioned. Similarly, for legal heirs.
So it is also your case that the property belongs to Jogesh and Jagadish in equal proportion, and they had been occupying their separate portion since long.
Jagadish in the meantime died.
Separate portion.
My lord.
They had been possessing separate
Yes.
portion. So there was some sort of amicable partition according to you also made out in the plaint. That is the your contention which has been recorded.
Purchase of this property by both the parties, below both the brothers. There was no
positive case was that equal proportion, both were residing separately.
My lord.
That is your positive case. Yes, next.
So, my lord, At the same time, the appeal court, what has, finding of the appeal court, I am placing, page 14 of the appeal court judgment, kindly see, top.
Page 14.
Page 14 of appeal court judgment,
Yes.
top. It is admitted, fact on record that suit property was purchased by Yogesh Chandra Samanto and Jagadish Chandra Samanto from Subimal Bandyopadhyay, by deed and was so and so executed on 4/10/1966. The case of plaintiff is that property purchased by both Jagadish Chandra Samanto and Yogesh Chandra Samanto was never partitioned. It is the finding of the appeal court.
No, it
The
is not
partition will
finding.
come, question of
It's not
partition
the
will come.
finding. Your case has been recorded here. It's not the finding. Your case from the injunction application has been recorded. It is the case of the plaintiff.
Yes.
Your case, it's not the finding.
But actually, from
Finding starts
might,
from.
my lord, might be, my submission would be very lordship. This was the might be finding of the appeal court, my lord. Always, my lord, it
The
has
case,
been
your
held by
case
the-
has been recorded.
Yes. For this reason, my lord, I am questioning myself, my lord, whether for this reason suit will be not maintainable. Once that has
Show
been,
me where it has been held that the suit is not maintainable.
without framing any issues, my lord, without any evidence, my lord, how
Show me where it has been said that the suit is not maintainable. Show me that.
my lord, your lordship kindly page
Yes,
20,
page 20.
page 20, 21, your lordship
So
also.
kindly come to page 20. That there is the finding.
My lord, my lord.
The court is of the opinion that the suit for partition is not maintainable, as the property of Yogesh Chandra Samanto and Jagadish Chandra Samanto was neither co-personary property, nor ancestral property, nor joint family property, but their purchased property in equal proportion. Purchased property can be demarcated by simple demarcation with the help of. Now the question is, if the suit for partition is as to why any party can be restrained by injunction not to enjoy his share.
Page 39.
What is your allegation in the injunction application?
Only 3 feet passages there, my lord. They have constructed.
Show me your injunction application. Show me your injunction application.
Injunction application. I have understood that, my lord.
Because it is also your case, both of you are occupying definite separate portions of the property. Maybe the property has not been partitioned by meets and bounds.
My lord, I am purchaser, my lord, I am.
Both of you
My-
have purchased.
My lord,
Your positive case is that both of you are occupying separate portions of the property. So show me your injunction application. What is your allegation now?
my lord, your lordship, kindly come to page 27 of my application.
Yes. Show me with regard to that only. What is the, why do you want injunction?
Yes, yes.
Show me that allegation.
The 14, 21. The page 21, your lordship, kindly have a look.
21.
27.
Yes, 27. Which paragraph?
Paragraph, my lord, paragraph, page 13 starts from page, my lord, paragraph 10.
27. এই যে প্যারাগ্রাফ
আছে তো উপরে আছে এখান থেকে শুরু হয়েছে প্যারাগ্রাফ 10 starts from the page 6 my lord. The A schedule suit property has never been partitioned by meets and bounds between Jagadish and Yogesh, and
So where is the passage? Where have you defined that passage?
my lord, your lordship,
Because paragraph 11 says that is trying to disturb and
my
trying to
lord,
make.
paragraph 10 page 27
Yes,
middle portion of first paragraph,
yes.
my lord,
No, that is with regard to the property is not partitioned that. Your allegation in the injunction application is paragraph 11.
your lordship, kindly come to my application, my lord, page 27.
Yes.
This is started to create an obstruction by making permanent structure. As the suit property has never been partitioned by meets and bounds any point of time. So the plaintiff on 26 June 2021 requested the defendant to partition the suit property amicably in respect of plaintiff's 0.0421 acre of land out of A schedule property, but they have refused to partition this property, and for that reason, the plaintiff is filing this suit and entitled to get degree for partition. It is to be mentioned here that on the southern side of A schedule property, there is a municipal road, and the plaintiff and her family members are using that road for ingress and egress from the dwelling house of the plaintiff. Said passage is one and the only towards the municipal road.
Yes.
Defendant is very to also disturb the peaceful possession. Trying to the next paragraph, paragraph
Yes,
11.
yes.
Plain.
trying to make construction over the passage.
Yes, this portion my lord.
However, you identified the passage. So injunction, your allegation is not that entire property is construction.
This is not my case. Only.
So show me however you defined the passage, because the injunction, if it is to be passed, it is to be a specific over a specific portion. Your allegation is that on a passage which is for the ingress and egress, how have you specified the passage in your schedule? Show me where you want injunction.
That is one. I am coming to that. No, that is not specified in my purchase deed. That there is a
Purchase deed, you have to specify that in the application. Unless you specify that, the injunction will be a vague one. Injunction cannot be on the entire property, because your allegation is that they are trying to make construction over the passage.
trying to change the nature and character of the supervisor. Both of them have constructed their building.
That is not your allegation. Now, according to you, defendant is trying to make construction over the passage. What is the passage? How have you defined the passage? Passage has not been defined.
That is only left for otherwise all over the purchase property building has been constructed. Only left portion is below 3 feet.
However, where have you said that? Specified. This is the 3 feet passage, 5 feet passage from here to here.
This is the passage below. The only one.
Where? From show me from the injunction application.
Because the
injunction order has to be passed on that specific portion.
On that basis.
So where have you specified? It's vague. What is the stage of the suit? I can direct the suit to be disposed of. Or if you want, there is no scope to pass any ad interim order because the passage has not been
Suit
specified.
is not maintainable is there. Your lordship can deal with.
Suit is, that is the prima facie. I will make that clear. That is a prima facie observation that will be considered at the time of hearing. That clarification I will make.
But regarding the passage, your lordship is
Passage you have not defined. You have not defined that passage.
in the plaint
Plaint you have defined. Where is that?
This 3 feet passage, nothing.
So you have,
For.
you have not specified the passage also in the plaint. So I'm clarifying that. Ashun, the Dina, this application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against the judgment and order dated December 23, 2024, passed by the learned Additional District Judge, 6th Court, Paschim Medinipur, in miscellaneous appeal number 131 of 2023, setting aside and thereby setting aside the order dated 31st of July 2023, passed by the learned Civil Judge, Senior Division, 2nd Court, Paschim Medinipur, in title suit number 258 of 2021. Just a paragraph. The petitioner herein filed a suit for partition and alternatively for demarcation and for other consequential reliefs. First up, in connection with the said suit, an application under Order 39, Rule 1 and 2 of the Code of Civil Procedure was filed. First up, the learned trial judge passed an ad interim order. No, the learned trial judge passed the learned trial judge by an order being number 2 dated July 9, 2021, directed the parties to maintain status quo over the schedule mentioned suit property, and the defendants were specifically directed not to make any kind of construction over the schedules mentioned suit property. First up, the aforesaid ad interim order of injunction The aforesaid order of injunction, the aforesaid order, the aforesaid interim order was ওটাকে ঘুরিয়ে লিখুন তো। Thereafter, the learned trial judge, by an order being number 17 dated 31st of July 2023, allowed the temporary injunction petition on contest in the form of status quo by making the ad interim order absolute till the disposal of the suit. Poster, being aggrieved against such order, the opposite parties herein preferred a miscellaneous appeal, being number 131 of 2023. First up, the learned judge of the first appellate court, after taking note of the cases of, after taking note of the case made out by the parties in their respective pleadings, have arrived at a prima facie finding that the property of Jogesh Chandra Samanto and Jagadish Chandra Samanto is equal in proportion, and they had been occupying their separate portion since long. On the basis of such prima facie finding, the learned judge of the first appellate court expressed its opinion that the suit for partition is not maintainable, and the purchased property can be demarcated by simple demarcation with the help of Amin, or by filing a suit for demarcation of share only. Full stop. Ms. Maiti, learned advocate.
7 Rule 11, Miller, Order 7 Rule 11 application filed by my
That is for a different.
kindly make
Make
an observation.
Ms. Maiti, learned advocate appearing for the petitioner, submits that the opposite parties herein took out an application under Order 7 Rule 11 of the Code of Civil Procedure, which was, however, dismissed by the learned trial judge.
No appeal. No appeal.
To stop, she further submits that such order has already attained finality. To stop, she further submits by drawing the attention of the court to the injunction application. Ms. Maiti submits that the defendants / opposite parties herein are trying to disturb possession of the plaintiff over the suit property and trying to make new construction over the passage for ingress and egress from the suit property, and trying to change the nature and character of the suit property. First up, after going paragraph, after going through the averments made in the injunction application, this court finds that the primary grievance of the petitioner is that the opposite parties are trying to make construction over the passage for ingress and egress from the suit property. First up, the passage for ingress and egress from the suit property to the municipal road, on the southern side of the A schedule property has not been specifically described in the schedule of the injunction application.
Which is only way of ingress and egress, no other.
First up, paragraph. Since the passage in respect of which the petitioner is claiming an injunction has not been described in the injunction application. This court is of the considered view that no vague order of injunction can be passed by the court, as the same will be, now the same cannot be implemented
This is the only way.
in case any violation is alleged. Full stop. In view thereof, this court is not inclined to interfere with the order passed by the learned additional district judge, 6th court, Paschim Medinipur. The order dated, order of the order passed by the on, what's the date? On
That's your option.
on December 23, 2024, in Miss Appeal number 131 of 2023. Full stop. It is however made clear that the observations made in the order passed by the learned additional district judge in the order impugned was only the prima facie observations, while disposing of the said miscellaneous appeal, and the learned trial judge, while deciding the suit, shall not be influenced by and the learned trial judge, the learned trial judge shall decide the suit without being influenced with such prima facie observations made in the impugned.
And the order impugned, my lord? Order impugned before your lordship, my lord?
I'm not interfering with the order impugned.
Lordship is not interfering with the.
Uh,
Can it be decided by the appeal court, my lord, while
No.
issue?
That observations have made it clear that with
Then
regard
your
to
lordship
the
kindly make an observation to that.
that observation I have said, without being, those are prima facie observations, without being influenced by those, the suit will be decided. That observation I have made.
Your lordship kindly make it.
I have made that observation. I have recorded those were the prima facie observations, and I have said while deciding the suit will not be influenced by those prima facie observations. With the aforesaid observations.
If it is not, my lord, modified or set aside, my lord, then what will be the legal impact?
Set aside means trial court's order revives, Ms. Maiti. What are you saying? These observations are there. If the miscellaneous appeals order is set aside, trial court's order revives.
Then your lordship kindly then may, my lord, give me liberty to file, my lord, an application specifying the, my lord,
That-
your lordship kindly make an.
No liberty. If you are at liberty to file, you can very well file.
Yes, I am at liberty.
So you can file. No
Kindly
liberty
get me
is necessary. Yes, call the next matter. Disposed of. Yes, next. You are very well aware what is the injunction application. You know the law. So
Lordship can, my lord, if your lordship so please.
No
you
liberty.
can. Thank you, lordship. I'll get to your lord.
yes.
Your Lordship, I have come before your Lordship against the order refusal of the order to add me as a party in a partition suit. And without assigning any reason, your Lordship, in the order sheet, Your Honor, she has summarized.
At what stage you have applied for addition of party?
On what basis?
At what stage?
At the stage, already preliminary degree has been.
So,
but recently I came to learn, Your Lordship. Recently I came to learn, Your Lordship. That is my thing. I came to learn after that preliminary degree, but here I can agitate my position. I was deceived. I was not made party purposely to deceive my share.
So you can very well challenge that preliminary degree.
I have challenged
You can very well challenge the preliminary degree by filing an appeal. You can very well challenge the preliminary degree by filing an appeal.
I have challenged.
Even if, assuming these are the final degree stage, even if you are allowed to be added, your shares cannot be allotted because in the preliminary degree, your shares have not been declared.
Now, you are already. Final degree has not been filed.
Can a final degree, in the final degree, any portion can be allotted in your favor? When no, so that is what I'm saying. You have to challenge the preliminary degree. Challenge the preliminary degree.
Already barred, Your Lordship. That is the thing.
That is a different thing altogether. If it is barred, then it cannot be helped.
Now, Your Lordship, I hear my position. Let me. The respondent has already admitted that I am a shareholder.
Where is that?
That
Where is the admission?
in their objection to my application under section Order 1 Rule 4, Order 1 Rule 10. Just a second.
Where is your application?
The objection, Your Lordship, that is P7, Your Lordship.
Page
Page 53, Your Lordship.
53, yes. Where is their admission?
Just saying, Your Lordship. '53, Your Lordship. The 53 is opposite party number 1.
Yes, Ashun. You want to submit anything more?
Pardon me, Your Lordship.
You want to submit anything more?
Your Lordship, I think, Your Lordship, I should be added at the party. I'm not seeking for any stay, Your Lordship.
Not stay.
I should be added so that I can contest the matter. Now, at this stage, I shall be able to agitate with the commission work, Your Lordship.
Intervention at this stage cannot be permitted. Ashun.
Your Lordship,
that no leave can be granted. This application under Article 227 of the Constitution of India is at the instance of an applicant under Order 1 Rule 10 of the Code of Civil Procedure and is directed against an order dated 11th of September 2024 passed by the Learned Civil Judge Senior Division 7th Court at Alipur in title suit number 127 of 1999. First up, the petitioner applied for being added as a party defendant in a partition suit, which is at the stage of final degree proceedings. First up, the learned trial judge has specifically recorded that the suit was decreed on 15th of December 2003 in plenary form. First up, it further appears that the The preliminary decree was challenged by the defendants. Second appeal also, it came up to second appeal. Yes. Not you, but the preliminary decree uh, the defendants of the partition suit challenged the preliminary decree by preferring an appeal being title appeal number 24 of 2004, and the same was dismissed, thereby affirming the preliminary decree. First up, the matter was carried before this honorable court in SAT number 1566 of 2006, and the second appeal was dismissed on 28th of September 2007, thereby affirming the preliminary decree dated 15th of December 2003. First up, the petitioners herein applied for being added when at the stage when a new partition commissioner was appointed to do the commission work, to undertake the commission work. First up, the learned trial judge rightly recorded that there is no scope to add the petitioner as a party defendant at this stage. First up, for such reason, this court is not inclined to interfere with the order impugned. The CO number such and such stands dismissed. There shall be, however, no order as to costs. Yes, next.
My lord, I'm paying for not this week.
Yes, what is this matter?
My lord, I'm paying for not this week, my lord.
Why?
My lord, as the learned counsel is not in a position to attend before this honorable court
Who
because
is the learned counsel?
my lord, Mr. Arindam Das. He's suffering from various physical ailments, my lord.
The learned advocate, ওনার নামটা record করে দেবেন. Such and such learned advocate appears for the petitioner and prays for an accommodation on the ground of her learned senior as on the ground of a learned senior. So she prays that the hearing of the matter may be adjourned for a week. So stop. As prayed for by the learned advocate for the petitioner, the hearing of the matter stands adjourned. You should read the document.
My lord, senior counsel Mr. Pratik Chatterjee is not able to come today. He is suffering from fever. I pray for not this week.
What is your name?
My name is Ashish Dev.
Who is your senior? What is the name of your senior?
Pratik Kumar Chatterjee.
Where is Mr. Mihir Kundu? Who is the advocate on record?
He has also not come today.
An accommodation has been prayed for on the ground of the learned advocate on record as well as the learned counsel who has been engaged to argue this matter. First up, as prayed for by the learned advocate for the petitioner, hearing of the matter stands adjourned for this week. For this week?
For this week.
For this week.
My lord, an application for expeditious disposal of a my lord, money suit, my lord, which was filed in the year 2006.
Yes.
My lord, expeditious disposal application, my lord. 2006 money suit, my lord. Trial not yet commenced, my lord. In the year 2022, my lord, the matter was transferred before the learned, my lord, commercial court at Rajarhat. My lord, since then, my
What
lord,
is the 151 application?
my lord, 151 application is an application which we have filed, my lord, for compliance of an order which was passed by a coordinate bench of this honorable court. My lord, my lord, what happened, my lord? My lord, what happened, my lord? The defendants prefer an application before the court below for production of certain documents. Challenging that, we came before this court that those documents are not in our possession; those are possession of the railways. So the court held that if they want those documents, they can approach the authority.
It is fixed for hearing on 27th of February.
February, my lord. But
any other interlocutory application pending?
No, my lord.
Suit is otherwise ready for hearing.
Yes, my lord. Yes, my lord.
Ashok. This is an application praying for expeditious. This is an application praying for a direction upon the
Learned Commercial Court at Rajarhat.
Learned Judge, Commercial Court, Rajarhat, District 24, Parganas North. কি বলে শুরু করলাম? This is an application to dispose of money suit. 3 money suits.
No, my lord, it is renumbered.
Oh.
Since it transferred, it renumbered. Initially, it was
the last number.
The last number, my lord, the present number is MS 47 of 2022 CC and MS Com 76 2024. That's how, my lord.
ওটাই লিখে দেবেন। বুঝতে পেরেছি কষ্টটা এটলে MS 47/2022 ... তিনখানা নাম্বার আছে। To dispose of such and such expeditiously. From the order sheet appended to the civil revision application, it appears that 27th of February 2025 has been fixed for hearing of the petition under section 151 of the Code of Civil Procedure. First, in view of the order sought and proposed to be passed, there is no necessity to issue notice upon the opposite parties. First up, however, the learned advocate for the petitioner shall be obliged to forward a copy of this application and along with this order upon the opposite parties or their learned advocates representing the opposite parties before the learned trial judge. First up, it has been submitted by the learned advocate for the petitioner that the suit is otherwise ready for hearing. First up, in the light of the aforesaid submissions made by the learned advocate for the petitioner, the learned judge, Commercial Court, Rajarhat, District 24, Parganas North, is requested to take up the hearing of the application under section 151 of the code on the next date fixed, that is on 27th of February 2025, and to dispose of the same expeditiously without granting any unnecessary adjournments to either of the parties. First up, the learned judge is further requested to dispose of the suit expeditiously without granting any unnecessary adjournments to either of the parties.
My lord, within a specific time period, my lord. Otherwise, my lord, it won't be considered, because if your lord
then this direction will not be passed. Supreme Court is merely because of the fact that your client chose to apply before this court, you will get precedence over other matters which are prior to yours.
My lord, kindly consider the last order, my lord. They
Kindly bring the Honorable Supreme Court's judgment deprecating the practice of giving a specified time frame for deciding the suits. Show me that decision. You are aware.
My lord, kindly
You are aware
my lord,
of
it's 20 years, my lord. 20 years, my lord, money suit, my lord, not yet trial, not yet commenced.
That is why expeditious hearing. Specified time frame, you do not know what is the pressure. There may be matters which are older than your matter. So then I will direct serially.
They can come before your lordship and
serially. No, that is why I told you. Merely because of the fact your client could choose to come before this court. Expeditious, this is what. Next.
This is
Yes, Mr. Gupta.
This is against order refusing to grant an order of injunction by the courts below. Trial judge,
Courts below.
if your lordship may kindly look to the both the courts order, none
Mr.
of the
Gupta, if both the courts below have refused, I'm directing to serve because there is no
one
scope
thing,
to
my lord, one thing
both
that
the courts
difficult.
concurrently
I
found.
understand, but kindly have a look to both the order. If at least 2 or 3 line has also been written, I understand that when both the court concurrently, but
Mr. Gupta, December it was dismissed.
kindly have a look to once the impugn later
Which
part. of
order?
the-
Which order you want to show?
The appellate court order is
Yes.
last annexer,
Yes.
2nd January 2025.
2nd January 2025. Yes, yes.
I'm
I've
sorry,
got that.
2nd January 25.
Yes.
Now, my lord, in the next page, the first page is the only case which has been made out. Second page, the learned judge in the appellate court recorded the law which governs ex parte injunction in 2006 5 SCC, which was possibly cited by the, because it was ex parte appeal. Thereafter, my lord, the page that page 183, the balance of convenience. Thereafter, one line, I do not find any urgency in the matter for granting ad interim. My lord,
That is the no urgency. Urgency you have to satisfy, Mr. Gupta.
I'm coming. Kindly come to the trial court, sir.
And most of the urgency is lost. So from December, you are without any interim order.
Undoubtedly, urgency I have to establish along with the other issues, the prima facie case, balance or irreparable.
Even if you succeed in proving those,
absolutely
urgency is not there, ad interim cannot be passed.
But the court has bypassed nothing to be taken into consideration just in one right records. And your lord,
that is why the miscellaneous appeal is still pending.
And
Mr.
your
Gupta,
lord,
I can do
it's not pending. It has been disposed of. It has been disposed of. It has been disposed of. Let the case be disposed of to the trial judge for speedy disposal.
No,
and it has been
prayer
disposed
for ad interim injunction is rejected. So miscellaneous appeal must be pending.
But it's not pending. The order indicates it's not pending. It has been sent before the trial judge.
Transferee court.
Transferee court.
Transferee court is the miscellaneous appeal.
Transferred to the court of ADJ. Oh,
yes.
I'm sorry. For disposal of appeal.
Yes.
Yes, I'm sorry.
So
Now,
Mr. Gupta, two things can be done. I can direct the appellate court to decide the miscellaneous appeal. Otherwise, you have to serve, then it is again to come. Even if the court is not satisfied with the urgency, then also the question would be whether
I understand.
Or I can direct. There are two things. Initial is also the ad interim.
Yes.
Two things can be done. If you want, the injunction application may be decided once for all.
The difficulty on my part which comes in, my lord, kindly turn to page 177. That is the trial court's order.
What happened? They have appeared before the trial court.
No, they have not appeared. And the difficulty on my part that the learned trial judge as well as appellate court only recorded that there is no urgency. But the facts of the case shows in 2024 September, there has been transfer of some undivided interest of the property. The deed I came across and I have annexed the deed itself. That
When
is
the
at
transfer
page
was made. When
157.
the transfer was made.
September 24. That I have stated in the plaint as well as injunction application. Kindly come to page 44 and 45. Page 44, 45. Both before the trial court as well as before the appellate court. Kindly, my lord, take turn to paragraph 14. 14, 17, 18, 19, 20. Why the necessity arose? 14, September 24, there has been transfer of some share. 17, I found that some persons who have purchased undivided, they are storing materials. Thereafter, on 20/12/2024, paragraph 19, the GD was lost before the police station that since there has been no partition, they cannot raise boundary wall and construction. And what I sought for injunction to prevent them from making construction. Therefore, if they go on, my lord, making construction, my lord, I will be affected. To some extent, protection, I do not mind going before the
I do
court
not know
below.
what happened because that was in December, 20th December. So 2 months have already passed. If they have constructed, I do not know what is the stage.
No, they have not constructed as yet. And if your lordship wants me to
both the
status
courts will-
is on today, If you
Status quo without defining, Mr. Gupta.
now, my lord, only one thing what I
I'm the
submit,
last person to pass that.
what I submit before your lordship. Your lordship,
Then I can do one thing. I will direct you to serve. It will appear
one thing
thereafter.
only, one thing. My lord, since there has been no partition, at this stage, your lordship knows, my lord, that the statements made in plaint and injunction are to be.
Yes, yes, I appreciate that,
Now-
but I am on the urgency.
I'm coming.
I'm on the urgency.
I'm coming. If these statements are treated to be correct, at least undivided share has been transferred by deed. I have annexed the deed in September 24. The deed also shows that these are undivided share. Now, my lord, they cannot make construction unless there is partition or there is some approval from the authority. Your lordship can protect me to this extent that there should not be any illegal construction.
Serve and come back. I will do that.
Some
After
kind
this-
of protection, some kind of, in any manner that they will not raise construction without
not
any
know
permission.
what happened because the GD was locked when they have purchased.
September 24.
So from September, so nobody knows what happened.
No, building, I am not,
Let them come. I am directing you to
building, I am
serve.
not concerned, my lord. But what they are doing,
Boundary wall.
they are creating boundary walls so that make a control over that. So all that I want, if there is no permission for building wall also, they cannot construct it. What is legally permissible to this extent that they will not construct boundary wall?
It is in which
This is
area?
Permission
It is
of
in which area?
this is my lord Hooghly Singhot.
No, Panchayat, municipality, what?
Panchayat.
Panchayat, up to a certain level, no permission is
No,
required.
but
Mr.
I
Gupta,
have
no permission is required.
No, your lordship is correct. But I have annexed the photograph showing that these are 10, 12 feet. This requires permission.
So it has been constructed already.
No. It's
What is 10, 12 feet?
My lord, to the extent of 6 feet, there is no permission
Yes.
required in law. So what I submit before your lordship, there should not be any construction dehoves the law, which is illegal.
What is the law? If up to 6, no permission is required, that is legal. Mr. Gupta taking advantage of this, they will construct. This will go against you. This will go against you because the law permits them.
Well, difficult would be that they will take advantage of the order and will again go on constructing.
Mr. Gupta, sir, आगे लिखूं. This application is at the instance of this application under Article 227. This application under Article 227 of the Constitution of India is at the instance of the plaintiffs in a suit for partition and for other consequential reliefs, challenging the order dated 2nd January 2025, passed by the Learned Additional District Judge Chandanagar in miscellaneous appeal number 18 of 2024, thereby refusing to pass an ad interim order of injunction. Mr. Gupta, Learned senior advocate appearing for the petitioner, submits that the opposite parties herein have purchased undemarcated portion of an unpartitioned property and is trying to raise construction on the best portion of the property. First up, he further submits that the opposite parties are trying to construct a boundary wall in order to take control over the entire property. First up, taking this court finds that the petitioner, where is that page, Mr. Gupta? You have
page 44. Page 44.
44.
Page 44. Paragraph 14 is the deed.
No,
17.
Paragraph.
Page 44. Paragraph 14 is the date of deed 2024.
It has been
18, 19, 20.
Mr. Gupta, Learned senior advocate, in course of his argument, pointed out the averments made in the application for injunction, wherein it has been stated that the opposite parties herein have partitioned have purchased unpartitioned and undemarcated portion of the suit property in the year 2024, and a complaint was lodged before the police authorities on December 20, 2024. First up, since a long time has passed since the purchase of the property by the opposite parties, and the complaints were lodged, and the complaint, one complaint or many complaints?
No, many complaints are there.
And,
Last
and
one is
several
20.
complaints were lodged, this court is not inclined to pass any ad interim order without hearing the opposite parties. First up, petitioner is direct petitioner or petitioners?
Petitioners.
Petitioners are directed to serve a copy of this application by speed post with acknowledgement due upon the opposite parties, and pass and file an affidavit of service on the next date. List this matter under the heading returnable matters in the monthly list of March
My lord,
2025.
The difficulty is if I serve, they will do it.
They will
again go on making construction to make this infructuous. Any sort of protection to some extent, they will not transfer the
আচ্ছা,
suit
ওটা
property.
returnable matters
Otherwise,
কবে আছে?
it will cause me greater problem, my lord.
তার আগে
I don't mind serving copy, but
তাহলে
they will not create third party interest to this. At least
creation of third party interest
I
is not a
understand,
part.
let them do,
They
but-
can transfer their
I
undivided.
know, my lord, but the transferee also will
Lispendence
be
is
getting
there.
a right to make
Mr.
construction.
Gupta, lispendence is there.
There is no bar in transfer. Your lordship knows the bar is on the person coming and taking construction.
So that
Your
is why.
lordship knows
So
that.
transfer third party
Your
interest.
lordship
Yes.
has ample experience.
No,
The
no.
moment
Yes,
I
hold the next
saw
matter. That is why I have fixed 28.
as most
Call the next matter. Yes.
as most
Returnable matters. Yes, next.
My lord, I'm for the petitioner.
Yes.
My lord, the petitioner before you is the wife. My lord, she got married with the respondent in the year of.
What do you want? Transfer?
Yes, my lord.
From where to where?
My lord, from the Lanet District Judge Poshchim Medinipur to the Lanet District Judge Krishnagar in
What is
Nodia.
the stage of the suit?
My lord, the next date is fixed for written statement for filing WS.
What is the date fixed for filing of the written statement?
1st March 2025.
1st of March. 14th of February was the date fixed.
Yes, my lord, I couldn't appear on that date, but before that, I appeared on 20th December 2024 and prayed for time.
Ashun. This application under section 24 of the Code of Civil Procedure is at the instance of the wife praying for transfer of the matrimonial suit number 221 of 2024 pending before the Lanet District Judge Poshchim Medinipur to the court of the Lanet District Judge Nodia at Krishnagar. So the petitioner is directed to serve a copy of this application upon opposite parties and by speed post with acknowledgement due and file an affidavit of service on the next date. List this matter in the monthly list of March 2025.
My lord, one thing, the next date is fixed for written statement on 1st of March. My lord, kindly.
Stay. No,
My lord.
File your written statement.
16 my lord, in this matter, my lord, I am appealing for the petitioner. Rejection of application for injunction by both the courts below. Before that, my lord, I want to draw your lordship's attention so the trial court
Verdict
judgment.
team,
Finally.
final.
So
Yes.
now I can turn to the plaintiff itself. The trial court certificate copy I have applied for, but not yet received. The appeal court judgment is there. I have annexed the photocopy of the trial court judgment. I am drawing your lordship's attention to the portion in respect of which, if your lordship can turn to suit for partition. In such a suit, I have the 1/3 owner, defendant number, performer defendant number 2, 4 and 5 and 6 are the 2/3 owners.
Proforma. What
Proforma.
mean as?
No. Proforma. Because why? Subsequently, it came to knowledge that 4 and 5 transferred their property in favor of defendant number 1 and 2. And
So now 1 and 2 is having 2/3.
2/3. And subsequently, it also appears that defendant number 3, alleged to have 4, alleged to have obtained my power of attorney, transferred the property in favor of
share also.
my share also.
So now the partition suit is not maintainable, Mr. Rai.
I have challenged that also, but that I have not executed the power of attorney. Now, if that be so, can you turn to page 24 once?
What is the injunction which you are now
Not to
seeking?
transfer. Why? After that, what? Yeah, logically turn to page 24.
Not to transfer your share, 1/3.
Yes, admitted share. My admitted share. Let them to the stay, I cannot object because it's admitted that yes, is entitled. Now, the appeal court rejected my application on the ground or dismissed my appeal on the ground that I have not challenged the amount of consideration money as mentioned in the power of attorney. I have challenged the power of attorney. There is no existence of the power of attorney. So, what is the need? I don't understand why the appeal court has proceeded in that fashion. If your lordship can turn to internal page 6 of page 7.
Internal page 6.
At the bottom, my lord will find
Yes.
the page numbers are there. Paragraph number 11. Last line, paragraph 10, my lord. The original agreement in question was produced this court, and yet the appellant did not challenge the execution thereof on receipt of consideration money 3 lakhs pursuant to such agreement. The agreement between my power of attorney holder and my.
Which paragraph?
It starts from paragraph 10, my lord.
Yes, it starts from paragraph 10. Which portion?
Last portion.
The original agreement.
The original agreement. It is between the execution.
For the nature of the documents of the extent largely differ with regard to the versions. The original agreement question was produced before the court.
And
the appellant
I challenge the
did
power of
not
attorney.
challenge execution thereof. Says execution you have not challenged.
Money receipt.
No, execution of the power of attorney. Show me that.
Yes, well, can turn to the plate itself.
No, what is original agreement? That is the power of attorney, or there is one agreement for sale?
Agreement was between my power of attorney holder and the defendant number power of attorney holder and the defendant number 3.
Power of attorney holder and the defendant number 3, because your allegation is that your power of attorney holder transferred to the third dependent.
The third dependent also transferred to your 1 and 2.
So show me what is your.
Normally, before that one can turn to page 24 once.
24.
Yes, my portion to my injunction application.
Injunction.
Yes. Your lordship, if I remember the middle portion. Best portion, better
Why
portion.
it's very difficult. Why you have made a micro Xerox?
That
why this?
It is there still going on. So our days, my lord, it does have it. Is
micro Xerox.
In our days, my lord, my lord is not habituated with this micro Xerox, but we are habituated in our college days.
Yes.
Your lordship, fine. অবশেষে এত করে তারা পার্টিশন করবেন
24 which portion?
লাস্ট মিডল পেজ লাস্ট অবশেষে
ইংলিশ প্যারাগ্রাফ
in the middle portion my lord will find better portion এর construction করবেন বলিয়া at the middle your bottom
I've got by meets and bounds.
Yes.
There or you
yes thereafter.
Yes, thereafter. Yes, I've got.
অবশেষে এত করে পার্টিশন করবেন না বলিয়া সম্পত্তি পার্টিশন করিতে অস্বীকার করিয়াছেন এবং নালিশ সম্পত্তি বেটার পোর্শনে কনস্ট্রাকশন করবে বলে হুকুম প্রদর্শন করে বাদীপক্ষ দায়ের করা যে গতান্তর ছিল না বিবাদীগণের বিরুদ্ধে অত্র আদালতে দিস ইজ টিএস নাম্বার 206 অফ 2019 নম্বর মোকদ্দমা দায়ের করিয়া
this is the suit.
Previous to this, before this suit, there is another suit was filed in the, yes, also injunction documents are required for declaration for the purpose of effecting partition. For effecting partition.
Yes.
There we have disclosed that it has wrongly been transferred in favor of this said person. This suit was withdrawn on the basis of the assurance given by this defendant number 1 and 2 that I will pay the money and we will purchase your share also from you. This is a specific statement made by
Yes, place that.
যে কারণে 1 নম্বর ইনজাংশন প্রত্যয়ন এবং বিবাদী পক্ষের নালিশি সম্পত্তির কনস্ট্রাকশন কার্য বন্ধ হইয়া যায়। সেই কারণে 1 নম্বর বিবাদী পক্ষ নির্বাহী হইয়া এই বিবাদী পক্ষকে প্রলোভন দেখিয়া গত ইংরেজি 1/12/2020 তারিখে বিবাদী পক্ষ নিকট হইতে নালিশি 6 শতক সম্পত্তি রেজিস্ট্রি করিয়া লবেন বলে এক চুক্তিপত্র সম্পাদন সম্বন্ধে 23,27,500 টাকা দিবেন বলিয়া 10 টাকা স্ট্যাম্পের উপর গত ইংরেজি 9/12/2020 তারিখে একটি বিক্রয় দলিল সম্পাদন করেন এবং বাদী সরল বিশ্বাসে 1 নম্বর বিবাদী পক্ষের পরিণত হইয়া অত্র আদালতে গত ইংরেজি 9/12/2020 তারিখে উক্ত টাইটেল সুটটি লয়েন। After that, they did not now, apropos to this, can you turn to the objection to this paragraph?
Who is the first defendant? He is your power of attorney holder.
No.
So this agreement, Mr. Rai, is between you and the first defendant.
Yes.
And for transfer. For transfer, you are not disputing this agreement. You said this agreement was entered into.
Subject to it is not that. It is when I filed the suit, then this first defendant approached.
You filed a suit initially. Thereafter,
the defendant said
obtained an order of injunction.
And
first defendant approached you and told, yes, I will purchase your share. So an agreement was entered into between you and the first defendant for transfer of your share. That's a consideration which has been mentioned. Now, are you disputing this agreement?
No.
You are not disputing. So transfer was made by the first defendant pursuant to this agreement.
No. I filed a suit when I came to know about the execution of power of attorney holder transfer the property in favor of defendant.
All right. Yes,
and it is subsequent one. Well, if you logically turn to the middle portion, my lord can turn to page 23, paragraph 3. My lord will be
23, paragraph 3, yes. Mr. Rai, only one thing. The appellate court referred to an agreement.
That is executed
agreement, not this agreement.
That is agreement is the power of attorney holder and the purchaser. That is the consideration. That is what I am saying. In my plate, I have categorically mentioned that that agreement has not been entered into between me and if you logically consider paragraph 31, what is the response to this allegation?
31 of
their objection, page 31, the objection to my this paragraph.
Page 31.
Yes.
Yes.
May I read it from page 30? Prokas থাকে যে at the bottom 1 2 3 4 5 6 lines from the bottom. Prokas থাকে যে done at the right hand portion my lord will find. Prokas থাকে যে ইতিপূর্বে বাদীপক্ষ ইতিপূর্বে হস্তান্তর বাদে পুনরায় তফসিলস্থ সম্পত্তি মালিকানা দাবি করিয়া অত্র আদালতের টাইটেল সুট নম্বর 206 2019 নম্বর মোকদ্দমা দায়ের করিয়াছিলেন। উক্ত মোকদ্দমা বাদীপক্ষ আমুক্তার প্রাপ্ত হইয়া শাহজাহান শেখ নুরুজ্জামান সম্পাদিত সম্পত্তি হস্তান্তর করা সত্ত্বেও এই উত্তরদায়ক বিবাদী পক্ষকে ব্ল্যাকমেল করিয়া প্লেনটিফ দাবি করেন এবং পরবর্তীকালে বাদী পক্ষ বিবাদী পক্ষ বরাবর একটি চুক্তিপত্র সম্পাদন করেন। So this is the admission of that agreement which I mentioned in my application for injunction. এবং এই বিবাদী পক্ষের নিকট হইতে নগদ 3 লক্ষ টাকা এবং হালি শহরে 757 বর্গ ফুটের একটি ফ্ল্যাট রেজিস্ট্রি করিয়া লয়েন। বাদীপক্ষ উক্ত চুক্তিপত্রের প্রাপ্তি স্বীকার সাক্ষীগণের সম্মুখে স্বাক্ষর করিয়াছেন এবং উত্তরদায়ক বিবাদী পক্ষ ওই চুক্তি অনুযায়ী উক্ত ফ্ল্যাটের মালিকানা ডায়মন্ড রিটেলার্স পক্ষে শরিক বা তার অংশীদার আশিস চ্যাটার্জিকে গত ইংরেজি এত তারিখে চেক মূলে এত লক্ষ টাকা সাজেশন দিয়েছেন। So even if my lord pause there for a moment, if I purchase the property where I am claiming to be the owner of the property, what prompted me to pay this amount on the basis of this satisfaction of the agreement? According to the appeal court, my lord, your lordship find the deed was executed in the year 2019.
Show me your prayers in the plaint.
Yes, if your lordship can turn to the plaint itself. It starts on page 18.
Where is the prayer?
Prayer, your lordship will find at page 21
21.
for declaration, partition, and first prayer is not binding upon me.
Where is that portion that you have challenged this power?
Yes, page 21 at the top.
Power of attorney.
Yes.
Power of attorney.
আরজি বর্ণিত দর্শনতে বাদীপক্ষে শত সমস্যা বিরোধী কোনো রাইট ডিটেলস তথাকথিত পাওয়ার অফ অ্যাটর্নি my lord got it page 21 at the top
আরজির বর্ণিত সম্পত্তি such and such উক্ত সম্পত্তি বাদীপক্ষের কোনরূপ রাইট টাইটেল ইন্টারেস্ট না থাকার
বা
তথাকথিত ইয়েস
পাওয়ার অফ অ্যাটর্নি বুক নাম্বার such and such ফোর্স থাকার
ইয়েস
অনুপক্ষ দলিল মূলে
দলিল মূলে 3 নম্বর
বিরোধী পক্ষ বা এত নম্বর বিক্রয় করতে 1 নম্বর বিরোধী পক্ষ নালী সম্পত্তিত জমিতে কোনরূপ সত্ত্ব ও মালিকানা অর্জন করতে না পারা সাধারণত উক্ত আরওয়ার I cannot challenge my lord, that is something else.
This is 1/3. This was transferred by virtue of which deed?
That is the deed which was executed on.
This deed you have challenged.
The deed your lordship will find schedule. No. Your lordship can consider that the deed numbers are there.
Which is that transfer deed? This no
4460 of 2019. Yes, 4640 2019, 4641 and 4645 2019.
These are the deed numbers.
Two decimal each to 3%.
Yes.
So if the Manakali pause here for a moment, a person who is claiming exclusive right over the property is denying my title on the basis that your power of attorney transferred the property in favor of me 2019. What prompted him, even if my lord Kali consider, what prompted him to admit that yes, I'll pay this amount to you and I'll give you for shelter, for alternative accommodation? That means, my lord, at least my allegation is to some extent correct. That is the reason he has acceded to such proposal. And the appellate court proceeded.
Show me your prayer in the injunction application.
Yes. That your lordship will find at page.
Nature and character.
Nature and character. তৃতীয় পক্ষ মানে page 25 মানে
so nature and character may be a difficult thing now. So
বা তৃতীয় পক্ষকে that is the only thing my lord I can ask.
Transfer.
তৃতীয় পক্ষকে কোনো that to my lord I am only restricting my prayer to 1/3.
1/3. So 1/3 has been transferred to which defendants or which opposite parties? Here
3 to 1.
1, 2 and 3.
Yes, your lordship find. Yes.
21.
No, I mean বিক্রয় কবুলাদের মূলে 3 নম্বর বিরোধী পক্ষ এত নম্বর বিক্রয় কবুলাদের বলে 1 নম্বর
page you are placing
page 21 your lordship the entirety the prayer portion
page 21 yes 1 নম্বর বিবাদী পক্ষ দলিল মূলে 3 নম্বর বিবাদী পক্ষ বা
মূলে 3 নম্বর 1 নম্বর
so 1 and 3
yes
not 2 not 1 2 and 3
1 and 3
so they should be restrained according to you from further transferring.
Yes, that is the only thing my lord to that extent of my share.
Yes, 1/3.
Yes,
so these are the 3 deeds.
Yes, that your lordship will find the 3 deeds mentioned in my plaint also. If your lordship
Mr. Rai, so by these 3 deeds
my 6 decimal transfer
your 1/3 share
6
was
decimal
transferred to defendant number 1 and 3
থাকতে পারে না তার মানে ডিডাক্ট ফর মাই স্যাটিসফ্যাকশন অলসো অতঃপর 3 নম্বর বিবাদী পক্ষ প্রকাশ করিতেছেন উক্ত পেজ 19 লাস্ট পেজ 19 প্যারাগ্রাফ 2 লাস্ট 2 লাইনস
yes
my lord will got it that is the paragraph number 2 of the plaint
yes
থাকতে পারে না তার সম্পূর্ণ বিপরীত কার্য হইতেছে তৎপর উক্ত 3 নম্বর বিবাদী পক্ষ প্রকাশ করিতেছে যে উক্ত ছল তৎসরি পাওয়ার অফ অ্যাটর্নি দলিল মূলে শাহজাহান শেখ রামপুরহাট এত নাম্বার these are the 3 deeds my lord got it নম্বর বিক্রয় কবুলাদের নালসি দাগের 6 শতক সম্পত্তি 2 শতক সম্পত্তি করিয়া তিনখানি দলিল মূলে তাহাদের বিক্রয় করিয়াছেন 1 2 3
3 নম্বর বিবাদীকে
yes now I can turn to page 18 that cost title that will
মানে প্রকাশ করিতেছেন যে 3 নম্বর বিবাদীর নিকট
It was initially transferred.
Third defendant, your share was transferred to third defendant.
Defendant. He transferred.
First defendant.
Yes. Innocent.
So now, first defendant is to be restrained because he has already transferred according to your plaint case.
Yes. And it is admitted to that extent also. So if my lord, they are the parties which they are on the ground, my lord, can you turn to page 18. They are Shopon Bokshi and Srimati the husband and wife.
Page 18.
Page 18, the
Shopon
constitution my lord
Bokshi.
will find.
Yes, so Shopon Bokshi.
And Srimati Bonasri Bokshi are the husband and wife. And the power of attorney holder is this person who is Mohammad Nuruzzaman.
So he has transferred to Shopon Bokshi.
Jaman.
He has transferred to Shopon Bokshi.
Yes.
So Shopon Bokshi is to be restrained.
Unpartitioned body admitted more than the admitted share, my lord. That will suffice the purpose. I am not trying to disturb the construction or whatever. They are not encumber and transfer more than the admitted share of the pit.
আসুন।
চলে যাই। তিনটে দিনে তিনজনকে করেছে এক এক করে দিয়েছে না না এইটাই করলো কে
Yes, what happened? Any problem? Mr. Rai, where is the trial court's judgment?
That is the photocopy I have annexed, but I've applied for one. That is at page 35.
35.
No, no, এই যে।
This application under Article 227 of the Constitution of India is directed against
তিনটে করে দলিলে ওকেই বিক্রি করেছে একে
an order dated 23rd September 2024 passed by the learned additional district judge Rampurhat district Birbhum in miscellaneous appeal number 18 of 2022, thereby affirming the order number 13 dated 16th of September 2022 passed by the learned civil judge senior division first court at Rampurhat district Birbhum in title suit number 89 of 2022. First up, the petitioners filed a suit for declaration, injunction, and partition. First up, is the specific case of the petitioner that the sale deed in the name of the defendant number 1 / opposite party number 1 has no effect in the eye of law, as the defendant number 3 / opposite party number 3 hearing had no saleable right in the suit property. First up, alleging that the defendant / opposite party numbers 1 and 2 are trying to change the nature and character of the suit property by making illegal construction, and they are also trying to alienate the suit property to third party. The petitioner herein filed an application under Order 39, Rule 1 and 2 of the Code of Civil Procedure before the learned trial judge. First up, the learned trial judge, after hearing the learned advocates of the respective parties, rejected the petition for temporary injunction by an order dated 16th of September 2022. First of being aggrieved, the petitioner being aggrieved by such order, petitioner preferred a miscellaneous appeal being number 18 of 2022 before the learned preferred a miscellaneous appeal being number 18 of 2022, which was disposed of by the learned additional district judge Rampurat district Birbhum by a judgment and order dated 23rd of September 2024. So by the said order, the miscellaneous appeal was dismissed. The learned judge of the first appellate court observed that the original agreement in question was produced before the court and arrived at a finding that the appellant / petitioner herein did not challenge execution thereof or receipt of the consideration money of 3 lakhs pursuant to such agreement. First up, after going through the after going through the pleadings, this court finds that the petitioner, this court prima facie finds that the petitioner has challenged the execution of the power of attorney as well as has challenged the execution of the power of attorney, and also that no right, title, and interest accrued in favor of the first defendant by virtue of transfer alleged to have been made by the third defendant in favor of the first defendant. First up, this court finds that a prima facie case has been made out by the petitioners herein. First up, the petitioner claims to have 1/3 share in the property, which, according to the petitioner, was transferred by the power of attorney holder / defendant number 3 herein in favor of the defendant number 1 herein. First up, in view thereof, this court is of the considered view that in the event the defendant number 1 / opposite party number 1 succeeds in transferring the 1/3 share of the suit property, which he is claiming to have acquired by virtue of the impugned deeds, there will be multiplicity of proceedings. First up, thus the balance of convenience and inconvenience lies in favor of the petitioner, and the petitioner will suffer irreparable loss and injury unless an order of injunction is passed in favor of the petitioner. First up, in view thereof, there shall be an order restraining the defendant / opposite party number 1 herein from transferring and or alienating the 1/3 share of the suit property, which he claims to have acquired by virtue of the deed numbers 464. These are the 3 deed numbers.
These are the 3 deeds.
By virtue of the deeds being numbers, এখান থেকে লিখে দেবেন না, page 21 এ 4640/19, 4641/19 and 4645/19, which was registered in the office of the additional district sub-registrar Rampurhat till the end of March 2025 or until further orders, whichever is earlier. Petition.
Subsequently, another deed lordship 5555 of 19.
That is not in the plaint, Mr. Sannal.
In the
neither here nor there.
In the prayer lordship, in the plaint lordship, that has been mentioned. Lordship.
Where plaint prayer?
Page 21, lordship. That
yes, page 21. Where is 55?
After these 3 deeds, lordship, the defendant number 3 lordship transferred the defendant number 1.
Defendant number 3 transferred to the defendant number 1 by virtue of these 3 deeds.
3 deeds. Thereafter, lordship, kindly consider the next line, lordship. By 3 deeds, the defendant number 3 became the owner. Thereafter, lordship, defendant number 3 transferred to the defendant number 1 by 5555.
So this is the deed by virtue of which the defendant number 1. তাহলে ওই একটাই হবে, 3টে deed হবে না.
Yes.
By virtue of which ওটা deed 3টে নাম্বার হবে না, 555, 4 4 4 5. 4/5/1990, which was registered in the office of deedটা কেটে দেবে till the end of March ওটা হলো petitioner is directed to serve a copy of this application by registered post with acknowledgement due upon the opposite parties by speed post with acknowledge serve upon all the opposite parties because since it is a partition suit কি হলো with acknowledgement due and file an affidavit service on the next date. List this matter in the monthly list of March. You can complete your service by then.
Yes, sir. It is Birbhum Lordship, 2 weeks or 2 to 3 weeks if necessary, Lordship.
2 to 3
In
weeks.
March, Lordship, it will complete, Lordship. If your Lordship direct the matter to appear on the next, Lordship. April.
তাহলে ওটা করে দিন এই এপ্রিলে এন্ড করে দিন আর মান্থলি লিস্ট অফ এপ্রিল করে দিন
Great.
Yes, next. Contested application করে দিন Yes, next.
So the suit for eviction, the petitioner is a tenant. Lordship, the suit was filed on 26 September 2016. Lordship, the defendant tenant filed the written statement. And Lordship, the appeared before the court below on 21st March 2017. My case
7-3 allowed.
7-3 allowed. Lordship, 7-3 filed in the year 2024. After 7 years of the filing of the suit.
So why 7-3? Non-compliance of 7-1 and 7-2.
Now, Lordship, my specific case in the written statement, and Lordship, I have the documents that I have due to since 2009. Lordship, the owner refused to accept the rent. I filed an application before the rent controller. HRC case has been started. HRC case continued. 2011, it was 2013, it was dropped. Again, I
not file 7-1. You did not file 7-2.
7-1.
No documents was produced to show that you deposited rent. What
Lordship,
can be
I have with my the documents along with the application of 2013 also that has not been considered. That continued. I have not filed it 7-1 because of the fact
that title suit is of 2016.
Yes.
Where have you filed this application on
before the HRC?
Rent controller.
Rent controller.
Yes.
Because 2009 I have filed the application that refused to accept the rent.
Maybe according to you, you are depositing before the rent controller.
So I did not file any application. Lordship,
why you should have said that I was depositing there, because this is the allegation.
Now, Lordship, in the written statement, I specifically stated that I am depositing there because they have. And Lordship, the 7-3 application has been filed after 7 years of.
What is your objection to 7-3? Have you stated all these facts?
Yes. Kindly come. My objection at page 36.
According to you, there is no default.
No default. And Lordship, I will produce the each and every challan.
File this application.
And Lordship, kindly consider 7.
Show me your objection to 7-3.
7-3 page 36. Now, Lordship, the time is concerned. Lordship, the time is according to the without praying for section 5. Lordship, 7-3 application filed after 7 years.
Where is the premises tenancy act?
Also, this is kindly come 1, 2, and then 3. So kindly consider.
But after
there is specific period that after entering of the defendant within a 1 month.
Give me a minute. So even after the suit was filed, you continued to deposit with the rent controller.
Yes. So
that is not permissible.
No.
But that is not permissible.
2009, I have started to continue paying up rent before the rent controller.
Maybe, but after the suit is instituted, can you pay before the rent controller?
Lordship, kindly appreciate. 2016.
After the suit has been instituted, you have been served with the summons. Can you still continue to go on to pay before the rent controller?
Rent controller, Lordship, I have started to pay 2019.
Sir, I accept you have started. I am asking you, after the suit has been instituted, you have received summons. Can you still continue to go on pay before the rent controller? Could not have.
So that
7-1C non-compliance.
Admittedly, I have not complied, but Lordship, there is a specific time has been mentioned that 1 month from the date of entering into appearance of the defendant, there should be an application of 7-1 that I have not. Now, Lordship, kindly come 7-3. Subject to Lordship, the time has been granted in 7-1 and 7-2. This
Under the statute.
Yes.
So you have not complied with that. 7-3 is automatic.
7-3 ought to have been filed within the time period along with the application. Even it ought to have been filed with the section 5.
What the learned trial judge has said.
Lordship, this is so far the delay is concerned, there is no consideration.
Your HRC was dismissed.
HRC dismissed 2011. Then again, Lordship, I have restored the same. That has not been considered. But I have the documents. And Lordship, the grounds of eviction is ejectment is the non-payment of rent and building is dilapidated. Not for reasonable requirement.
Nothing can be done.
Lordship, the building is the...
Show me that after appearance, you can continue to pay before the rent control. Show me the law. After service of summons.
And Lordship, kindly consider the delay because they ought to have been filed.
What delay? Delay cannot be considered. Even 1 day delay cannot be considered. Have you gone through those judgments? Are you aware of these judgments?
I will come back, Lordship.
All right. Ashun, after some argument, the learned advocate appearing for the petitioner seeks an adjournment to assist this court on the next occasion. As paid for by the learned advocate for the petitioner, list this matter in the monthly list of March 2025. Difficult. Yes, next.
Great.
I am for the petition.
এই বইটা দিয়ে দিন।
It is a matter of expeditious disposal, my lord.
Of what?
Not order 7, my lord, application filed by the, my lord, petitioner, order 7, rule 11, and the my lord, the plaintiff file an application, order 6, rule 17, and the, my lord, injunction application.
Order 7, rule 11.
Yes, my lord.
It says section 7, CPC. Orders.
Rejection of plaintiff. My lord. Last, my lord, page certified copy, my lord. Last page is.
So what is the date fixed for order 7, rule 11?
No, date fixed for, my lord, 7/3/2025. Both the application.
Both the applications.
Both
Order
the
6, rule 17.
Yes, my lord.
Order 7, rule 11.
Yes, my lord.
7th of March 2025.
Yes, my lord.
Both the applications.
Both the applications. My lord, several times, my lord, the plaintiff.
What is the suit for?
Suit for, my lord. The plaintiff, my lord, filed a suit.
What is the suit for? Plaintiff will file the suit. What is the suit for?
The suit for, my lord, declaration and, my lord, injunction.
Declaration of what?
Declaration of the, my lord, suit for, my lord, property of, my lord, residential building. My lord, dependent part.
This application under Article 227 of the Constitution of India is at the instance of the defendants in a suit for declaration of title and permanent injunction, praying for a direction upon the learned civil judge junior division 6th court at Alipur to dispose of title suit number 881 of 2021 expeditiously. First up, it has been submitted by the learned advocate appearing for the petitioner that those two applications are ready for hearing, objection and other things.
Yes, 3 applications.
Submits that the applications under Order 6, Rule 17 of the Code of Civil Procedure and another application under Order 7, Rule 11 of the Code of Civil Procedure are still pending before the learned trial judge. He further submits that the said applications are ready for hearing. First up, in the light, in view of the order thought and proposed to be passed, there is no necessity to issue any notice upon the opposite parties. However, the petitioner shall be obliged to forward a copy of this application and this order. Now, along with this order upon the opposite parties or their learned advocates appearing on their behalf before the learned trial judge. First up, in the light of the aforesaid submissions made by the learned advocate for the petitioner, the learned civil judge, Junior Division 6th Court at Alipur, District 24 Pargana South, is requested to take up the hearing of the aforesaid applications on the next date fixed, that is on 7th of March 2025, and to dispose of the same as expeditiously as possible without granting any unnecessary adjournments to either of the parties. Stop, ঠিক আছে? Disposed of, আর ওই উপরে লিখে দেবেন না, ওই it has been submitted, আর একটা লাইন লিখে দিই, it has been submitted by the learned advocate for the petitioner that the aforesaid applications have been fixed for hearing on 7th of March 2025. কোথাও রেকর্ড করে দেবো, সাবমিশনের যায়। Yes, next. Disposed of.
Some time.
Yes, next. Yes, Mr. Haldar. This is the matter which you were mentioning yesterday.
Malar. It has appeared, but
why you apprehended that this will not appear?
No, I under the impression the matter is fixed for argument to the learned court below on 17th, on 18th, and then Malar on 20th. In this way, Malar, the matter is being taken up by the learned trial judge.
All right, yes.
Malar, this is a Malar suit for eviction entirely on the ground of default and reasonable requirement.
You are a tenant.
I am a tenant.
Yes.
My father, originally my father was the tenant in respect of the suit property.
What is the impugned order?
I am coming back.
What is the impugned order? Thereafter, you will submit. What is the impugned order?
This division is directed not against an order by which my application for filing additional written statement to the amended plaint has been rejected by the learned court below.
On what ground?
The amendment was allowed on 4th March 2021.
4th March
2021. I have annexed this. Annexed here, my lord.
March order 6 rule 17 allowed.
My lord. My lord, if you also kindly comes to my lord, the page 10.
Now, when did you file this application?
No, my lord,
show me that order 6 rule 17 allowed.
My lord, page 10.
Page 10.
At the bottom.
Yes.
Plaintiffs are directed to file amended plaint within 1 week from the date of the order.
Yes.
Till date, no amended plaint has been filed. What I did, my lord, since my lord, they paid for amendment seeking introduction of 2G, my lord, I took out an application for amendment of written statement. That was rejected since I did not avail this opportunity because I could not file unless and until the amended plaint is filed and unless the copy is served upon the defendant.
So you are challenging the order dated 10th of February 2025?
Yes, my lord. 25 as well as my lord, the order dated 17 January 2023 by which my application for my lord amendment also rejected.
When did you file the application under order 6 rule 17?
My lord, I filed, my lord.
What is the date when you filed this application under order 6 rule 17?
7 September 2022.
7 September 2022.
My lord.
There, you took the points which you wanted to take now in additional written statement.
My lord.
So that was rejected, Mr. Haldar.
No, my lord.
Why you will be allowed to take
no, my lord,
this plea now?
No, my lord.
Show me
No,
your
my lord.
schedule in the
My lord.
order 6 rule 17 and the additional written
My lord, kindly
statement.
have a look at my lord, order 6 rule 18.
Yes, yes, I appreciate that.
Order 6 rule 18, my lord.
Yes.
At till today, no amended plaint has been filed. Can you consider this aspect?
But now thereafter, you have filed order 6 rule 17 to bring those facts which was rejected. Whether after that you can be allowed to take these pleadings.
Well, if you
Satisfy me on that.
if you my lord, ignore this, well, can you consider
Leave
this?
aside that.
Well, now what I am praying for filing, give permission to file additional written statement to the amended plaint.
Did you take this point that they did not file their amended
Yes,
plaint?
yes.
Show me that where you have raised this point that they have not filed their additional
Well, till today,
amended
order
plaint.
sheet, well, materials on records, order sheet says so.
Show me that you have raised this point, Mr. Haldar. Show me that you have raised this point before the learned trial judge that they have not filed.
My lord, in the trial court, I did not take this. But order sheet
If
shows.
you have not,
Well, order
Haldar,
sheet
nobody
shows.
knows. You should ought to have taken this point before the learned trial judge.
Well, order sheet shows.
Records were before the learned trial judge. Learned trial judge could have allowed your prayer or rejected their amended plaint.
My lord,
You are now seeking.
Well, till today, no amended plaint has been filed. Can you consider
Yes,
that?
you have filed your amended plaint.
My lord, my lord.
Have you filed, yes or no?
Yes.
Show me the amended plaint. When have you filed?
Well, let me clarify. Well, let me clarify one thing, my lord. My lord,
Mr. Haldar, I will come back to you. Let me see when he has filed the amended plaint.
This is the amended plaint. And
When
after
have you
that,
filed? What is the date of when you have filed this amended plaint?
and after that, we have filed revised plaint also. And kindly see.
No, what is the date when you have filed? 10th of March 2021.
Yes.
Mr. Haldar, do you have a copy of the order dated 10th of March 2021?
And my lord, kindly have a look.
Yes, yes, give me a minute. Yes. Do you have a copy of the order dated 10th of March 2021?
this is the entire certificate copy. There is no order.
Show me the order dated. I do not
No,
want to see the.
no order. 10th of March 2021, no order. This is the certificate copy, original certificate copy. By this order, amendment allowed. There are can comes to next page.
One of the plaintiff died. We have thereafter we have filed the revised plaint.
Maybe, but show me that you have filed the amended plaint on 10th of March. There is no recording in the order.
My lord, this may be the mistake on the part of the judiciary. But what I am on, kindly have a look. Their application, page 26, they are stating that inadvertently the defendants were failed to file the additional written statement of the last amended plaint. This is their amendment.
Sir, so if according to you, let us accept that he has not filed his amended plaint. I will allow you to raise that point before the learned trial judge. Then your additional written statement is not necessary.
Well,
If
this
the learned trial judge will look to the records. If it is not filed, then he cannot lead evidence on the basis of that amended plaint. If it has been filed, you are out of the court. So I will make that observation. If that is not filed,
one additional statement is very much necessary.
No. If his amended plaint is not there, no additional written
From the record, it shows that no amended plaint is filed. Well,
That
your
apart,
lordship can.
your order 6 rule 17 on self-same ground was rejected, not challenged.
Well, now I have challenged this.
What?
Yes,
Order
I have
6 rule
challenged both the
17?
order. Yes.
Order 6 rule 17
Yes.
you have challenged.
Yes. Kindly have a
Where
look
is
at
that?
the
Which order?
Well, 17 January 2023. I have challenged these both the orders.
Yes.
Yes, Malad, in what ground it has been rejected? Kindly have a look at this order. 17 January 2023.
So I will proceed one by one. You move this revision application under order 6 rule 17 first. Let me first pass an order on that. Thereafter, I will go to the next order.
Malad, both the orders I have challenged this.
Yes, yes.
Okay, Malad.
So that was the prior order. So whether that was right or wrong, I will consider that.
Malad.
Yes. Move your order 6 rule 17.
Malad, Well, the original tenant, my lord, died in 1983. This is an admitted fact. My lord, there are.
Sir Haldar, I am not on that.
My lord,
Show me that you have satisfied the proviso to order 6 rule 17. Show me that.
my lord, this
It was after the commencement of trial. Admittedly. Your application under order 6 rule 17. Show me that you have satisfied order the proviso to order 6 rule 17.
So, my lord, kindly have a look at this.
Show me your
Yes.
application. What is your explanation with regard to proviso to order 6 rule 17?
My lord, on 7 September 2022, my lord, I filed this. And their
When the
application
trial
was,
commenced?
but their application, my lord, was filed.
No. When the trial commenced?
After amendment, my lord, the plaintiff that was recalled, that was allowed.
Mr. Haldar, have you annexed your original written statement?
I have not.
Give me your original written statement. Was this case made out that after the demise of your father, you and your mother was the joint tenant?
That is the plain case also. That is the plain case also. Kindly have a look at the plain case.
So you are admitting that plain case. So there is no necessity to amend your written statement. If that is so, they have admitted your case. Why are you filing order 6 rule 17?
My lord, let me highlight the conduct of the.
I will come back to you.
No, this plea was not being taken.
So what was the plea with regard to how you became a tenant? You are trying to make out a new case now.
No. Kindly have a look at the plain
Show me
case.
that it was your case in the written statement. What is the
Well, kindly have a look at the plain case, my lord. Case 13.
1-3, yes.
This is a plain case, my lord. At the very inception, at the filing of the suit, paragraph 3.
3, yes.
That until termination of the tenancy of the opposite parties, the opposite parties were joint tenant.
Who are the opposite parties?
Opposite parties, my lord, means, my lord, the Pradipta Chakraborty and his sister.
So
Srimati
Pradipta
Jhumur Banerjee.
Chakraborty,
Page 12, your lordship will find the opposite party.
Yes.
Pradipta Chakraborty, Jhumur Banerjee.
This is the brother and sister.
Brother and sisters. So, my lord,
they were the, according to them, they were the tenants. But you are trying to make out a case, you along with your mother was the joint.
No, Kali, let me proceed. Of the suit at a monthly rental of rupees 420 only payable according to the English calendar month under the petitioner. Be it mentioned herein that the father of the opposite party, Utpal Chakraborty, was inducted in the suit poverty in the year 1971. And after the date of said Utpal Chakraborty, the said tenancy was returned in the name of her widow, Srimati Niharika Chakraborty, that is the mother of the opposite parties. And an agreement was also executed in between the parties on 11th August 2003, wherein it is agreed in between the parties that the rent shall be increased 5% in every after 3 years, and after demise of said Niharika Chakraborty, the opposite parties became the joint tenants in respect of the suit property. So, my lord, they have, my lord, filed the instance of treating the present petitioner as tenant. Then, my lord, kindly come to the, my lord. Page 18.
Yes.
Plain. That originally 1.8.
Page 18, yes.
5.1. That originally Utpal Chakraborty was a bona fide monthly tenant in respect of the suit premises under the present plaintiffs at a monthly rental of rupees 135 per month payable according to English calendar month. That Utpal Chakraborty died in the year 1983. I am the son of Utpal Chakraborty, Pradipta Chakraborty, the present petitioner, leaving behind his widow Shrimati Niharika Chakraborty since deceased. And according to section 2G of the West Bengal Premises Tenancy Act 1997, a fresh tenancy has been executed by and between the plaintiffs and the said Niharika Chakraborty since deceased, the widow of the deceased recorded monthly tenant, and the relationship of landlord and tenant between the plaintiffs and the Shrimati Niharika Chakraborty since deceased.
What is this? This is the
5.1, my lord. They have introduced 2G.
Revised plain.
Revised plain. Revised plain was filed, I am telling, my lord. These
Yes.
My lord, the Shrimati Niharika Chakraborty died in the year 26 May 2007, leaving behind the present dependents, being the son and married daughters. And under the provision of section 2G of the 1997 Act, the time limit of 5 years were granted to them for continuing the said tenancy, that is the suit premises.
So in the revised plain, these paragraphs were added.
Added.
Yes.
The revised plain, my lord, was filed, my lord. Lordship will find, my lord, the order dated 12 July 2023. My lord, wherein, my lord, in the meantime, my lord, the plaintiff number 1 died. My lord, legal years are already on record. Your lordship, I have handed over to the, my lord, the entire order sheet. The plaintiff, my lord, died. My lord, they were directed, my lord, to file revised plain. Pursuant to order dated, my lord, 12 July 2023, my lord, they filed this revised plain on 19 July 2023. 12 July 2023.
Yes.
12 July 2023, my lord, plaintiff number 1 died. And my lord, his legal years are already on record. That is the reason why plaintiff was directed to file revised plain. And they filed on 19 July 2023. That revised plain. My lord, 1983, my lord, my father died. As soon as my father died, my lord, right of tenancy inherited by, my lord, this is the view, my lord, Honorable Apex Court, my lord, says, my lord, the right of, my lord, inheritance, my lord, prior to this 1997 that came into effect, my lord, that cannot be curtailed. So, my lord, unless and
Sir Haldar, these points you take at the time of hearing of the suit.
Yes, unless and until I am
I'm not going to the
I
merits
am
of
not
the
giving,
matter.
unless and until I am not giving the,
I have to see what was your original defense and what the defense which you are trying to now incorporate by way of an amendment, and what stage. These are the things which I will consider. Whether you were a joint tenant, whether you were not a joint tenant, what is the law. Those points you will be entitled to raise at the point of final hearing.
This is a judgment facts, my lord, for the disposal of the suit.
No.
My lord,
For the
unless suppose the amended plaint is concerned, till today no amended plaint is filed.
All right. If no amended plaint is not filed, they will not be allowed to. I am considering your application under Order 6 Rule 17 now.
No, my lord,
I am not on the additional written statement.
No, I am both. I am both on February 10th.
First place your Order 6 Rule 17 first.
No, my lord, because
Let me consider that.
No, my lord, my second application is for permission.
Second application you want first.
Second.
The reason for rejection, one of the reasons for rejection was the earlier order.
No, my lord, kindly have it.
Because your application.
What are the reasons, my lord? I am placing, my lord. What are the reasons? 17 January 2023. In the course of hearing, in the
not that, Mr.
no
Haldar,
written objection has been filed by the plaintiffs.
Mr. Haldar, you have challenged 2 orders in this application. The subsequent order was rejecting your prayer to file additional written statement. Yes or no?
Yes.
One of the grounds was your Order 6 Rule 17 was rejected.
Why rejected? Kindly consider this.
So let us go
let
to
me place only the grounds. Only let me place. Well, order dated 17 January 2023. No written objection has been filed to the application of the amendment by the plaintiffs. In the course of hearing, learned advocate for the defendant submits that the plaintiffs had incorporated the facts pertaining to Section 2G of the West Bengal Premises Tenancy Act 1997. And as such, the certain facts are needed to be incorporated for proper adjudication of the suit. On the other hand, learned advocate for the plaintiff submits that the defendant has not provided any explanation in the application as to why the said amendment could not be brought earlier. He also submits that the amendment application prepared by the plaintiffs was allowed in the year 2021, and the defendant got the opportunity to file additional written statement, but it was not filed. He also submits that the defendant subsequently cross-examined the PW1 and he argues that the instant application filed by the defendant is an afterthought and an attempt to drag the proceedings. At the very outset, it will be pertinent to state that the suit was posted for argument after giving repeated opportunities to the defendant to adduce evidence. At this stage, defendant preferred the instant amendment application seeking to incorporate certain facts. It will be pertinent to highlight that the defendant has got the opportunity to file additional written statement against the amended plaint, but he did not file the same and continued to cross-examine. How? These findings is totally inconsistent. I was permitted to file additional written statement unless and until the amended plaint is filed. How can I be permitted to file additional written statement? This is absolutely perverse finding by the learned trial judge.
Yes.
And since the suit was posted evidence that the argument, it was incumbent on the part of the defendant to establish that despite due diligence, he could not have brought the amendment earlier. No explanation has been provided by the defendant either to the application or during making oral submission. And this is the reason, because I was given opportunity to file amended additional statement, but I did not avail this. And only on that ground, the second application was also rejected only on that ground. Kindly have a look at order dated 10 February 2025.
Yes.
10 February, middle portion, learned advocate for the defendant files an application under section 151 of the Code of Civil Procedure with the submission of additional written statement in connection with the amendment that has been allowed by the learned court on 4th March 2021. Be allowed. It is pertinent to mention that in the order dated such and such, this court has mentioned that the defendants have foregone their right to file an additional written statement. How, this observation? By this order, I have not foregone because, learned court below says, I was permitted to file additional written statement. I did not avail that opportunity. That is the reason why my application for amendment was rejected. But unless and until the amended plaint is filed, and that is served upon the defendant, I am not in a position to file additional written statement to that said amended plaint. Till today, no amended plaint has been filed. Record shows
What
this.
point you want to take in the additional written statement? Where is that?
That after the death of my father, Utpal Chak.
Where is that? Show me that. What points you wanted to take by way of additional written statement?
Unless and until the permission is given to file, but I have not filed this.
What is
because
the law?
From the plain case it appears that is their case. The original tenant died in 1983. As soon as my father died, right of tenancy devolved upon me. And you have admitted me as a tenant, filed the suit for eviction. Now you are seeking for introduction of 2G. Because my right of inheritance of tenancy right, that cannot be curtailed by 1997 Act. The Supreme Court says, recently says this. Because this additional is very vital for the judgment.
What is the procedure, Mr. Haldar, for filing of the additional written statement? What is the procedure contemplated under the Code of Civil Procedure for filing of the additional written statement? You will only file an application praying for leave, nothing more.
Order 8 Rule 9.
Yes, Order 8 Rule 9. What is the procedure to be followed? Only a application, 2-line application, permit me to file additional written statement, nothing more. What is the procedure?
My contention is that
I am asking you, what is the procedure? I do not know. I want to know the procedure. Order 8 Rule 9, only 2-line application. I kindly give me leave to file additional written statement. So that leave will be allowed. Then you will introduce a pleading. Is it the procedure contemplated?
Additional written statement to the amended plaint. This is not subsequent pleading. I am not coming under Order 8 Rule 9.
You are not on Order 8 Rule 9.
I am coming.
You are not on Order 8 Rule 9, Mr. Haldar. Be sure what you are saying. If you say you are not on Order 8 Rule 9, yes, I will consider other thing.
At the stage of
I am saying leave, also. Leave.
So, what was your application for? Leave for under Order 8 Rule 9 or not under 151? Give me an opportunity in the light of that. Be sure, because you cannot sail on two boats. You have to make a specific submission. What is the nature of your application? What is your application? Don't sail on two boats. Choose one of the boats.
Order 8 Rule 9.
Order 8 Rule 9. So what is the procedure contemplated under Order 8 Rule 9? Only 2-line application. Give me leave. Or nothing, something more is required.
Yes, my lord. That is.
Loudly, I
It
cannot
was-
hear.
It was not specifically so pleaded, my lord.
What not specifically pleaded? Only paying for leave, one application. Nothing more is required.
I have to state the reasons, my lord.
Not only the reasons, subsequent pleading also has not to be filed along with that. Or after leave will be granted, you will file thereafter. What is the procedure? I want to know from you.
Already there is order of this honorable court for expeditious disposal because he.
That is neither here for expeditious hearing, the procedures cannot be wiped off. Procedures have to be followed.
At the stage of argument, he has filed this.
Sir, please wait. Let Mr. Haldar conclude thereafter. Yes, Mr. Haldar. What is the procedure contemplated? You are so vociferous, now you have stopped. Or you want time? But no stay.
17th was the date. This
Maybe.
Monday.
Mr. Haldar, maybe. If you want time to get yourself prepared, I can grant time, or else I will be passing an order. For an interim order also, I have to assign reasons. Rejection also of the prayer of interim order, I can also assign reasons.
Kindly admit it for the timing, matlab, kindly fix it, matlab, next week.
But no stay, Mr. Haldar. No stay.
In the meantime,
I can assign reasons why I will refuse.
No,
I will
what?
refuse to pass an order of stay. I will assign reasons for that.
For 7 days. 7 days?
No, no, no.
Will not do. No, kindly consider this.
No, no, no. It's a purely dilatory tactics.
7 days, matlab, the fact is very judgment, matlab, for determining.
It's fixed for argument, Mr. Haldar.
For determination of the, matlab, for record source. Kindly consider this aspect.
Then I am deciding this application.
Kindly consider.
No, no.
Kindly give me one. Let me just file.
I can adjourn it you on your prayer, but no stay. That is what I am making clear. No stay. Or else I will pass an order.
Next Wednesday.
And if you say, yes, they have not filed the amended plan, that point you can raise at the time of arguments. If that is not there, law will take its own course. Order 6, Rule 17, Order 8, Rule 9, I can decide this. Choice is yours.
Kindly take it next Wednesday.
But no prayer for stay.
Kindly.
If you insist, make a prayer, then I will record reasons why I am refusing.
Kindly, matlab, secure me for 1 week.
No, no, no. What is the, today is the date fixed?
Monday was the date fixed.
What is the next date fixed?
Yesterday was the date fixed. Then matlab, Thursday. Not
Thursday is tomorrow.
tomorrow.
I can,
Yesterday
tomorrow,
was the date fixed. So, but thereafter, tomorrow.
argument is in the first half.
My lord. My lord.
I can keep as item number 1 tomorrow as a last chance. Not 1 week. Tomorrow, first item. That is all I can do for you.
My lord.
Tomorrow likhe din. After some argument, the learned advocate for the petitioner prays for an accommodation to assist his court on the next occasion. Considering the fact that tomorrow is the date fixed for argument, list this matter tomorrow under the heading continuing matter at the top. Yes, what is the next matter? Mr. Haldar, take back this, make a photocopy of this. You take back your amended plan, make 1 copy of this. Yes, also you take instructions whether it was filed on that date. If you can obtain any information slip from the court that the amended plate you have filed on that date.
Within this short time,
Within this short time, you cannot get an information.
I shall try.
All right. Then I will have to pass an order of
I
stay
shall
then.
try.
Yes, next.
I am for the petitioner. My defendant is the petitioner.
Mr. Chatterjee, you are appearing.
Next one. Next one.
Yes.
Defendant is the petitioner before your lordship. A suit for specific performance.
Surfacey.
I am telling you, Surfacey is pending much prior to filing of this suit. I am defending in the suit. We have taken out I have taken out an application for order 7 rule 11. That is pending much before filing of the application for order 6 rule 17. Without considering that, the learned court considered their order 6 rule 17.
Order 6 rule 17 was taken up prior, though it was filed at a later point of time. What is the law, sir, which is to be taken up? First,
Rejection of my application for
I follow that you have filed and your application under order 7 rule 11 is a prior in point of time. Taking in order to cover up your points under order 7 rule 11, they have subsequently filed an application under order 6 rule 17. That was taken up prior. What is the law I am asking you? Which one is to be taken up?
my application is prior.
Are you ready with any judgment on this?
The thing is, this is a prima facie lordship considered surfacey proceeding is pending.
That is on order 7 rule 11. Your grievance is order 6 rule 17 was taken up at a prior point of time, though it was filed later. Rightly done.
Fact is this, they are aware of these surfacey proceedings, and not only that, they have taken out an application.
Which order you are challenging?
Order number 19 dated 5/10/2020. Learned trial has considered this surfacey proceeding is pending, and not only that, lordship find further finds.
For hearing of order 6 rule 17.
This is the other way around. It has been allowed by the learned trial.
That you have not challenged. Where is that order?
Last order number 19 dated 5/10/2024. Today is fixed for passing.
Has already filed on perusal of the proposed is the issue involved both particular proceeded at own risk. What is the order? No, for hearing of the order 6th of January 2025 was fixed for hearing of the order 6 rule 17.
Other way around.
It does not appear it has been allowed. What are you saying?
So, substance it has been allowed.
No. Next order C, 4th of April for hearing the written objection, if any, in the meantime.
Particular wording is absolutely misnomer. What
it does not appear it has been allowed.
On the contrary, on my application, that is on that order number, what you find that the earlier order number 11 dated 12/10/2023.
It does not appear that order 6 rule 17 was allowed. Take instructions.
Challenging absolutely clear to the civil proceeding is part.
That is on merit. Order. It does not say that order 6 rule 17 has been allowed. What you are saying?
If you proceed at his own case of the plaintiff without deciding the issue at this time. The operative person last line.
That I have seen. The case proceeded at his.
Actually, for the first time, I am seeing this type of order.
I can direct you to serve, but stay will not help.
The earlier portion of the order, you will find
neither order 6 rule.
This proceeding should not continue. Section 34 of the Civil Act.
But did not allow your application under order 7 rule 11 either. Order 7 rule 11 has not been decided. Order 6 rule 17 also has not been decided.
Then,
the learned advocate appearing for the petitioner submits that by the order impugned dated 5th of October 2024, the application under order 6 rule 17 has been allowed. However, on a perusal of the said order, it does not appear that the said application was allowed. First up, petitioner is directed to serve a copy of this application upon the opposite parties by speed post with acknowledgement due and file an affidavit of service on the next date. List this matter in the monthly list of March 2025.
In time, my lord.
What stay?
Both the
Move your application order 711 on the next date. Stay will affect your right. Yes, call the next matter.
Lord, proceedings, Lord, before the National Green Tribunal under the Lord, the East Kolkata Wetlands Lord, Act. I am not made a party to the proceeding. Nothing has been served upon me.
What are you challenging?
Lord, the order of demolition of my house. Order of
Mr.
demolition.
Chatterjee, subject to correction, there is an order passed in the division bench in public interest litigation matter.
Lord, it is not based on that. There was a separate proceeding filed, Lord, by one
Who
of
is
the
appearing for that authority?
There is no, Lord, caveat. And they are going, Lord, to date, Lord, to demolition.
You stated that no.
I've annexed the order. Annexed the
No,
order.
no. There was no public interest litigation
Nothing
on this.
is nothing. Kindly looks to the order, my lord.
Any others were included? I was not at.
Number of parties were impleted. I was not, my lord, made a party.
No. Maybe that.
My lord.
Maybe you are not party, but
My
a
lord.
public interest litigation.
There is nothing that comes on record there. Nothing that comes on record there. My lord, this is the ছবিটা দেখা. This is the wetland they are talking about. Have a look at it.
Mr. Chatterjee, kindly come to page 60.
60, my lord.
60.
Yes, my lord.
See WPA P358 of 2023.
My lord.
25th of July order.
Under
Under public interest litigation.
Yes, my lord.
So, this is the reference. So, some orders were passed. That is why I am asking you.
Not with respect to, my lord.
Not with respect to you, maybe.
Yes.
But this has to be seen.
Lordship sees it. I have problems on
Who
that.
appears for the what is the date of demolition?
Today. Today is the date of demolition. My lord, nothing given to me, and this is the wetland. Look, if this is wetland,
who appears?
Mr. Amitesh Banerjee then appeared. It's
Come
there
at
on
2
record.
p.m. Mr. Amitesh Banerjee then appeared. He is not
Now, my lord, I have to serve.
Where is your purchase deed?
Yes.
Kindly come at 2 p.m.
I'll take 2 minutes, my lord. If it comes at 2 p.m., my lord, I have a. If it
3 p.m.
After that, my lord, it's difficult. If it comments to your lordship, I'll take 2 minutes.
Yes.
Kindly looks to my purchase deed, my lord, at page 36, and schedule is at 45.
Schedule is at page 45.
45. Kindly satisfy.
Bill land.
Yes, my lord. Bill land. Bill land. I bow down, my lord, but that is no longer bill today.
That is a disputed
Conversion.
question, Mr. Chatterjee.
I have a right, my lord, of hearing. I have a right to be heard
Mr.
before
Chatterjee, do you have a copy of that order? Page 60.
My lord,
kindly take out that order, come at 2 p.m.
Look, I bear with you for one moment. Bill land, I completely
Chatterjee,
understand.
there is no difficulty because I was a part of that.
I understand, my lord.
So these several matters were moved.
I bow
with
down, my
regard
lord.
to this.
I bow down.
So if that is so,
yes,
and then it is to be heard by the Honorable Division Bench.
My lord, with a lot of respect.
Come at 2 p.m.
If there was, if it was, my lord, an outcome of that,
I do not know whether it's an outcome of that.
That your lordship would need to, my lord, hear the other side. But by that time, my lord, they'll demolish it.
Maybe. I do not know.
They'll demolish it. My lord,
By now they have demolished.
They haven't. I have instruction.
If by now they have not
The
demolished, they
right
will
of
not.
hearing, my lord, is inbuilt in the provision itself. My lord, suppose, my lord, whatever I have done is wrong, but I have a right of hearing.
Right, come at 2 p.m.
Achha,
Come at 2 p.m.
Come at
Bring that judgment, that order. Page 60, there is a reference of a public interest litigation.
We'll get that.
25th of July 2023.
We shall get that.
And there is also the orders of the National Green Tribunal. In that page, we will be finding reference. Another order of 4th of March in a writ petition. This series of orders
may have been. I am not on that at all. But if I am
bring
not heard, if I am not heard and my building is being demolished, the act gives me a right of hearing.
All right.
It's a right which is ingrained in the act.
2 p.m. or 3 p.m.
2 p.m. 2 p.m. আচ্ছা এই অর্ডারটা একবার বার করার চেষ্টা করো। Yes, we have got the copy of that order, my lord. That order, which your lordship was, my lord, takes up CO number 23.
23.
23. Monika Das.
You want Monika Das to be taken
Monika
up
Das,
first? All
yes.
these are analogous matters.
All analog.
Same facts.
More or less same. The one, a little bit here and there, but more or less the same. My lord, looks to my lord the order, my lord, which your lordship was pleased to pass. Here what happened was the canals were, my lord, being, my lord, blocked. Because the canals were being blocked, the people who got their, my lord, livelihood out of those canals, they moved, my lord, this petition, saying, my lord, that their livelihoods are going. My lords directed the authorities to see, my lord, whether there was any, my lord, unauthorized construction by blocking them. This was sent, my lord, to the authorities to find out the illegalities.
Yes.
There I had a right of hearing. I am not saying, my lord, that your lordship decides whether, my lord, my authority, my construction is right or wrong. I am saying that I ought to have been heard. I was not.
Where is the order of demolition?
Yes. Kindly takes up, my lord, in Mollika's petition. Well,
in this is Mollika Das.
Yes, my lord.
Yes.
No, 18-1. 18-1 too.
No, this is the NGT order.
Yes, my lord, kindly takes up 69 first,
Yes,
which
69.
is the NGT order. This is the order.
69.
69
is the deed.
I am sorry, my lord. This would be in Mollika. This would be different. In Mollika, my lord, it would come to 101. I'm sorry, 91. Are Mollika de bo.
91.
Yes, yes, I'm right.
18th January.
18 January, 9 starts from 93. 93.
Not 91.
No. 93 in Mollika.
93. Yes.
Yes, Lord. Sees Ankur Sharma, my lord. That's the
Yes,
petitioner.
yes.
And then your lordship will find the dark numbers given, my lord, at paragraph 3.
Paragraph 2.
3, my lord.
186, 192.
3 is the details.
No, there are dark numbers also in paragraph 3.
Yes, my lord. But 3, my lord, the details have been given. That's fine.
So you do not belong to any of these.
I belong to this. I belong to number 5 and number 10.
Number 5
and number 10.
In this Mollika.
In Mollika.
Yes.
Number 5 and number 10.
Yes.
The order of demolition is being passed here. Have a look at.
But this is the order passed by the National Green Tribunal.
Yes, my lord. This is one which is challenged before your lordship.
National Green Tribunal order can be challenged.
Yes, it's a tribunal. Your lordship's court has entertained it. My lord,
you have the copy of the
I have it.
Green Tribunal Act.
Yes, yes.
Because I think there is a provision of appeal against an order passed by.
My lord, where there is no, my lord, national justice granted, which is ingrained in the Act, 227 lies. This is the order of this honorable court. I was apprehensive about that. That's why I've got the, my lord, the judgment of this court. Kindly have a look at section 19. The section 19. Section 19, my lord. The provision of national justice is ingrained. I will have to be heard. And have a look at this is the recent, my lord, decision of this honorable court. Though it's not a ratio as such, but it has been entertained. And interim orders have been passed. Once it's a tribunal, my lord, 227 will lie.
Same is beyond the jurisdictional authority of the learned tribunal.
That
Why?
is in that particular matter. I'm not on that. I'm just on saying on jurisdiction, nothing more than that.
Mr. Chatterjee, if you say that you are not heard,
yes,
you can approach the National Green Tribunal saying that I was
Lord,
not
if
heard,
I'm not
praying
heard,
for recalling of this order.
Lord, your lordship knows better than me. If an ex parte order, ad interim order is passed,
you have twofold remedy.
I have a remedy before your lordship.
You have a remedy.
I have exercised it because of the extreme urgency. My urgency, my lord, before the tribunal, I cannot go up and say that, please hear me right now.
because today is the date of demolition. They will never hear me.
Why?
They never. Their date
That
will
is-
come after 3 months.
No.
So I
That
have
is-
a remedy, my lord, before your lordship.
Getting the certified copies.
Remedy, Mr. Chatterjee, that is the discretion which the court can.
Absolutely, my lord. But
So-
the other part kindly appreciates, there, my lord, the certified copies are not being given to me because I'm not a party here. I am not a party here.
That can be.
This is, my lord, why I'm before your lordship. I have to, my lord, survive. My lord, kindly have a look at, this is the wetland. Have a look at it. This is wetland.
That is because of you.
But they're not because of me. So the government has done it. My lord, Bill in 1901, never a water body anywhere. Suddenly, my lord, somebody, my lord, comes up and says, this is water body. So, my lord, 5,000 families are on the roads. 20,000 families on the roads. There is a limit to everything, my lord. Tribunal can't just say that, look here, I have the power, go and demolish it. Cannot. You've got to hear me.
Show me that page 93, where is the order of demolition?
That's
Where
it.
it has been said that it is to be demolished.
Can we
Today,
have a look at 91?
91.
এটা মল্লিকা দেখছিস?
No, this is 93. You said this is the
Yes,
demolition
sir.
order.
That is NGT order.
Yes.
And
NGT
pursuant
order
to that
directs
DM's order.
demolition.
Pursuant to that DM's order. 91.
Show me that operative part directing the DM to pass an order.
Yes, yes.
The operative
আচ্ছা
part-
এটা প্রথমে ওই অর্ডারে দেখাতে হবে।
912. The state consents them.
এক সেকেন্ড দা। মিলর্ড
At the end of it.
Yes, pursuant to this order, this order was passed when?
This order was
The
passed,
order
Milord, on 9th of
18th of January.
We didn't know. Then
Yes, pursuant to this, 91 is the order.
and then 13th November.
91 is of 13th of November.
And it gets approved in.
And it gets approved, Milord, in a later date where Justice, where Mr.
By the AGT.
In 172, the NGT, Milord, passes an order of demolition.
No, pursuant to this, you said 91. What is this 91? DM's order.
Yes, Milord, DM's order.
Yes, show me that today is the date of demolition. Where is
Yes.
that?
Oh, yes. That is, দেখো একবার আজকের ডেটটা, Milord, that's a subsequent.
Where is that? Is
That's a-
directed to dismantle the
Devkumar has-
illegal building.
I was not.
I'll tell you
I
that.
was not served with the demolition notice.
I'll tell you, Raj.
দেবকুমার
বল জায়গাটা বল।
কোনটা দেখছো তুমি?
দেবকুমারের পেজটা বল।
68.
পেজ 68.
68 capital A. Here, দাদা, third floor.
হ্যাঁ, এই যে 68A, Milord, 19th of
60?
অন্য দিতে হবে।
এখানে তো আমাকে সার্ভই করে।
Milord, kindly look.
Not in this matter.
In all matters. This is
No, in which matter, which page is the order of demolition?
Milord, it has been annexed in the other matter. Milord, there
One
are
matter, the order of the tribe.
20,000 families, Milord, they are all running from here to there. So we took, Milord, 1 hour to, Milord, prepare this. 1 hour we had, Milord, to prepare and come and pray for leave before your election. A. In connection with the above noted reference, Ankur Sharma versus State of West Bengal, it is to inform you that your godown, such and such, shall be demolished on 19th of February 2025.
When you came to know of this order?
Milord, this was passed
Show
on
me
the
your pleading
19th
that
of,
when you came to know. Show me your
19th
pleading.
of February, we came to know this Saturday.
Show me that from your pleading.
From my pleading. Yes. অতটাও কি লিখেছে? I give me 1 minute's time, Milord. I'm sure, Milord, we would have said something. No, Milord, there is no averment to that. When we came to know, Milord,
You had knowledge, Mr. Chatterjee.
we could not have had
Because
knowledge,
inquiry was made.
Milord, even
Although
if-
you have not specifically stated when you came to know.
Milord, even if we had come to know, Milord, your lordship,
You could have approached there. Because Mr.
Milord, I
Chatterjee,
could not have approached.
you have filed earlier, the authorities would have been heard before.
So I'll tell you,
So you
Lordship,
are
why.
coming on the very last day.
I'll tell you, Lordship, why. But
So knowledge of the order, this notice is very much important.
I bow down to your Lordship. Today, Milord, the situation is that they are going to demolish it today. Milord, I take it for instance, Milord, this is a mistake on the part of the lawyer. I am telling your Lordship, we came to know, Milord, only, Milord, on Saturday. Because it's not there, your Lordship would only take my word for it. But even if they come up and show that we knew about it earlier, Milord, your Lordship would take an adverse view, I understand. But today, Milord, whatever is on record, and by that time I can file an affidavit saying that we've come to know, Milord, on 19th. We could have come to know. We'll file an affidavit to
So
that.
according to you, you came to know on 15th.
Yes, Milord.
I was served with the 13 November letter on 10 February.
10 February.
Again, we 91 at
Sir, Lordship, দেখেছেন। দেখেছেন, দেখেছেন।
What?
In paragraph 9, Milord, we have said that, Milord, that we've come to know of the 13 November order, Milord, on 10th, which is page 91. Which is page 91. Milord, I don't actually.
So where have you stated?
Paragraph 9. Paragraph 9.
Paragraph 9.
Any petition your Lordship takes, your Lordship will find that government. This was
Served
from
with
the
an
DM.
order on 10th of February
Yes.
2025.
That is the DM's order.
That is the DM's order.
DM's order. Page 91.
Mullika was not served with this 68.
Page.
Mullika was never even served, Milord, with anything. Milord, the husband was, Milord, taken into confidence.
And this notice of demolition.
Yes, notice of demolition.
Here in your case, here no notice of demolition has been
No,
served.
no. On
Mullika, no demolition notice.
No.
Only DM's note order.
Dio Shah, Milord, Dio Kumar Shah, he got the notice only on Milord.
All right, let us proceed one by one. Mullika, no demolition notice.
No, on the husband.
Served on the husband.
Husband is not the owner.
So you had the knowledge.
I can take a
Had the
technical.
knowledge, maybe.
I can take a technical plea.
Yes.
So, I can take a technical plea.
So no notice served upon the petitioner.
Petition. Everywhere. All the matters, Milord, your Lordship will find no notice. Milord, that we were part of the proceedings. Even that. You're taking away where I stay. There are places where there is a go down. That's my livelihood. Goes back to Olga Tellis. Forgets about everything.
Yes.
You're taking away my livelihood.
So only this no notice served. Others notice served.
No. Milord,
if you have annexed 68A.
68A, Milord, we came to know only on Saturday.
All right. So this notice was served on Saturday.
That it will be demolished.
Yes.
But with respect to the proceedings, Milord, there was nothing.
Awesome.
Lord, kindly, your Lordship passing an interim order.
That I do not know. Let me start. I do not know when I will end what comes in my mind.
I bow down. Right. May I have your Lordship's leave? Lord, returnable whenever your Lordship pleases. I've got.
Plot numbers, where do I find, Mr. Chatterjee?
Yes, my learned friend, Mr. Dr. Milord, will assist your Lordship on that. Plot numbers, I have indicated. Page gulo just correlate করে দিবি 5 নম্বর and 10 নম্বর is Mullika.
Lordship, I'll just assist your Lordship. This is page 93 of Mullika's writ petition. Kindly takes my lord the
only
order
one
dated.
thing, kindly come to the order of all these petitioners. Their lands are within this paragraph 3. One of the plots within paragraph 3.
Yes, ma'am. That is there. That is there.
Petitioner claims to be the owner of LR tag numbers 226 and LR tag number LR tag numbers বলেছেন তো 226 and 234 এটা হচ্ছে মল্লিকাটাতে, মল্লিকা হচ্ছে 23, হ্যাঁ, 226 and 234 measuring about you own the entire 9.24 acres.
My lord, I am there, one of the, my lord, holders. Now I am not there everywhere.
Claiming to be the ocean owner of a portion of করে দিন, of a portion of.
My lord, the RS numbers are reflected in my deed. So my lord, if lordship also refers to the RS number,
tag number
correlation would be easier.
157.
Yes, yes, correlation would be easier.
তাহলে করুন না, a portion of এলা tag numbers 226 and 234 within bracket লিখুন corresponding to RS tag numbers 157 and 156 respectively. Full stop. The petitioner alleges that only on 15, Mr. Dotto, kindly hear the order so that the facts are not gone wrong.
My lord,
that only on 15th of February 2025, the petitioner came to know that the building constructed on the aforesaid plots will be demolished only on 19th of February 2025. The petitioner claims, the petitioner alleges, the petitioner alleges that no notice of any proceeding was served, no notice of any proceeding for demolition of the constructions raised by the petitioner on the aforesaid property was served upon the petitioner. First up, the petitioner further alleges that the petitioner is not a party in the proceedings being original application number 01/2024/EZ, wherein the National Green Tribunal passed an order directing constitution of a committee to elicit the veracity of the allegations made by the original applicant before the National Green Tribunal. Paragraph. Mr. Chatterjee, learned senior advocate appearing for the petitioner, submits that the no notice of inspection of the site in question as contemplated in the order dated 18th of January 2024 passed by the National Green Tribunal in the aforesaid original application was served upon the petitioner. First up, he further submits that that no notice of any demolition of the structures constructed by the petitioner on the aforesaid plots was also served upon the petitioner. First up, he submits that today is he submits that the petitioner has come to know that today the demolition shall take place. First up, Where have you stated that you have applied for the certified copy of the tribunal?
My lord, just give me a moment.
Mr. Chatterjee further submits that the upon going through the application under Article 227 of the Constitution of India, this court finds that the petitioner has specifically stated that she could not, that the petitioner could not, petitioner could not submit the application for certified copy of the orders passed by the Honorable National Green Tribunal in
Para 11, my lord.
OA number.
My lord, para 11 I have mentioned.
Yes, I have seen that. 1 of 2024. As the petitioner is not a party to the original proceeding. First up, after going through the order of the National Green Tribunal dated 18th of January 2024, this court finds that a committee was constituted and such committee was directed to inspect the site in question and submit its report within the time limit specified in the said order. First up, since it has been alleged that the petitioner was neither served with any notice for inspection and no notice of any demolition was served upon the petitioner, and considering the fact that the demolition is to take place today, that is bole ajker date ta diye dein, this court finds that the petitioner has succeeded in making out a case of urgency. First up, considering the fact that the petitioner was not served with any notice prior to the inspection, and also that no notice of demolition was served, this court is of the prima facie view that the principles of natural justice has been violated. First up, it is well settled that existence of it is well settled that this court under Article 227 of the Constitution of India can exercise such jurisdiction even if there is an alternative remedy, alternative statutory remedy of appeal provided under the relevant statute under certain exceptional circumstances. সাবধানে দেখবেন, খুব দামি জিনিস। এটা সাবধানে দিন, দামি জিনিস। Yes, call the next matter.
24 Lordship, I am for the petitioner Lordship. This application is by challenging the order dated 11 March of 2024 passed by the Fast Track 5 Court, Barashat. In
What is the
connection with
nature of the order?
Lordship, the wife asks for the 40,000 and get 25,000. Lordship, but the problem is that the order
You are for the husband.
I am for the husband. The order is passed without heard me. Lordship.
Without hearing you.
Lordship, it's a ex parte order, Lordship. It's a ex parte.
Yes, if it is not demolished by now.
It's a ex parte. It's a ex parte order, Lordship. In time of hearing, I'm not able to appear, Lordship. That's why.
You have chosen not to appear.
No, Lordship. I tell you,
Initially
Lordship.
appear, then initially appear, then chooses not to appear.
Lordship.
Initially appear.
Lordship, at first she filed a miscase which has been dismissed for default, Lordship. And thereafter she filed this miscase, Lordship.
My lord, they filed the suit for divorce. In the suit for divorce, I filed a section application for maintenance that was registered as miscase number.
Lordship, I tell you, Lordship, I filed a 27 of Special Marriage Act, Lordship, for decree of divorce, Lordship, and in the proceedings, she filed a miscase for alimony pending right under section 36, Lordship, which has been dismissed for default. The miscase number 20 of Lordship, just give me a time, Lordship. Miscase number.
Yes, what can be done? You did not appear, you did not show cause.
Also, she not comply with the subject to correction, Lordship. Not comply with the Honorable Court, Supreme Court judgment, Rajnish versus Nyaya. She not
25,000 for the wife and 2 children.
Yes, Lordship.
What is your income?
Lordship, BSA personal.
48,000, Lordship.
BSA personal, Lordship. More than that.
Lordship, kindly
70,000.
Yes. Lordship, kindly give us liberty to Lordship, kindly give us opportunity to do hard the
No.
again, Lordship.
Nothing.
Lordship, she also not filed the.
What is the stage of the suit?
Lordship, suit is going on evidence. We are taking time because the order of the maintenance was not complied with.
I can do one thing.
I filed.
What is the area alimony?
Lordship, what is this? Area alimony since
as per this order?
Since inception 2020 2018. Nothing has been paid, my lord. May I submit one thing? Allow me to, Lordship, in the court of the London Magistrate before Alipur, I filed a 125 application. That application was disposed of, directing the husband to pay maintenance at the rupees of 11,000. My lord, they challenged before the London Session Judge. Session Judge reduced the amount to the tune of rupees 9,000 rupees. I filed a execution case before the London Magistrate. In the said execution case, they are paying 14,000 per month because of 9,000 rupees, and for the area total 14,000 rupees. But in respect of this order, nothing has been paid.
Lordship,
they are about to pay extra 11,000, 14,000 plus 11,000.
But so this 25,000 is over and above of that 9,000.
9,000, Lordship.
Allow me, Lordship. 9,000 has been awarded by the London Magistrate.
Yes.
Then 11,000 has been awarded by the London.
It was reduced to 9.
9.
So, and here 25.
No, my lord. That has not been decided. Only I am entitled to get pay 29,000, 25,000 minus 25,000.
Minus 9,000.
Yes.
Where is that? Where it has been
that has not been
stated.
I'm clarifying only that.
My lord,
Lordship,
I'm clarifying only that. So
Lordship, she
you
is getting
25,000 plus
Lordship.
9,000.
No, I'm not getting that also. Lordship,
I will make sure that
subject to your lordship correction, lordship subject to your
that amount has to be adjusted along with this. 9,000 he has to pay in that, balance is to pay.
Get full, lordship.
Lordship, kindly give us opportunity to do reheard the matter as.
Yes, I can do that, provided, provided you go on paying at this rate.
Lordship, I'm paying, Lordship, I'm paying 14,000.
25,000.
I'm paying 14,000.
No, 14,000. Pay at this rate. It will be decided. It will be adjusted thereafter. If you are willing, yes. You cannot say no. This order will go. Again, he will delay that. That cannot be done. If you are willing, I can set aside this, provided you go on paying at this rate. And after it is decided, it will be adjusted.
Kindly reduce the amount, Lordship. I have other responsibility towards my
You also have a responsibility towards your wife.
Lordship, I'm paying, Lordship. I'm paying 14,000, Lordship.
I appreciate that you are a very responsible person. Fulfill your responsibility to all of them. Ashun. The order dated 11th of March 2024 passed by the learned Additional District Judge, First Track Court, number 5, Barasat, District 24, Parganas North, You have given the plot numbers with regard to the petitioner numbers.
Yes, the
The
RS number is indicated.
RS, LR,
LR, I'll just.
and the whether notice of demolition served,
Yes.
not served, date of coming to the knowledge.
Yes.
These are the three informations which are required.
But I'll take you only my learned junior will submit in a moment.
Yes.
Yes. He's just indicating the LR, everything is there.
দিয়ে ওটাকে পাঠিয়ে দিন। Yes, call the next matter.
25, I am for the petitioner. I am praying for expeditious disposal of my lord.
Of
Title suit number 185 of 2011, my lord. I am the plaintiff petitioner.
What is the stage of the suit?
My lord, kindly come to page 67, my lord. Next date is 15th May 2025, my lord, for SR and AD, my lord. Defendant number 6, for SR and AD, defendant number 6 died. I have filed amendment plaint, my lord.
Unless the service is complete, how can the suit be directed to proceed? Awesome. The petitioner has filed this application praying for a direction upon the learned civil judge, senior division, first court Kontai, district Purbo Medinipur, to dispose of title suit number 185 of 2011 expeditiously. So in view of the order sought and proposed to be passed, there is no necessity to direct issuance of notice upon the there is no necessity to direct the petitioner to issue notice upon the opposite parties. However, the petitioner shall be obliged to forward a copy of this application along with this order upon the opposite parties or their learned advocates representing them before the learned trial judge. First up, record reveals that 24th of July 2024 was fixed for filing of the amended plaint and for service returns in respect of the substituted defendants. First up, the petitioner, the learned advocate appearing for the petitioner could not satisfy this court that the yes, next.
Milord, this is a suit for expeditious trial. Milord. It's an ejectment suit initiated in 2014. Milord.
What is the stage of the suit?
Framing of issues, my lord. But in this, between these stages, there are many things happened. That is, on the prior stage, that is 2014, the defendants appeared. That's a respondent now here. They appeared, and then the case initiated, and then it was substituted. The other party was added because the defendant expired at that time. After from 2017 to 2019, they never appeared, and the suit gone for ex parte trial. And the complainant appeared, his chief was done, and at the verge of completion, that is framing of the order, passing of issuance of the order, the next day we found that the suit was fixed for service again. Then we served, and suddenly in the year 2022, my lord, the respondent started excavating the floor and making some constructions unofficially without intimating the petitioner. An injunction was moved and injunction was granted in our favor.
Written statement filed.
Written statement is filed by them in this year, my lord, after 10 long years, with a nominal cost of 500.
You have not challenged that order.
My lord, we tried to challenge, but the court didn't accepted our objection and said that let the
Issues have been framed, no.
not yet, my lord. We have we have filed the issues. and all.
Suggested issues you have filed.
My lord.
Ashun. This is an application under Article 227 of the Constitution of India, praying for a direction upon the learned Civil Judge, Junior Division, Second Court at Alipur,
লর্ডশিপ, আপনাকে হাত জোর করে ধন্যবাদ আজকে ম্যাটারটা রাখার জন্য। আমি খুব চাপে আছি। এনিহাউ,
ম্যাটারটা তো আছে লিস্টে।
হ্যাঁ হাজি আছে।
হ্যাঁ বলুন।
লর্ডশিপ, আমি দুটো অ্যাপিল ফাইল করেছিলাম অনারেবল ডিআরএটিতে। লাস্ট থেকে 3 নম্বর পেজ, 43, লাস্টের দিক থেকে 43, প্যারাগ্রাফ 70। এখানে অ্যাপিল 12/2024 এটা ডিসমিস করেছে।
My lord, I am appearing the respondent bank, my lord. They have
Respondent
bank, my lord.
bank.
Yes, my lord. I have not received any copy, my lord.
It is a
My
copy.
lord, they have
অ্যাডমিশন হবে, প্রথম এসছি।
my
Since he is
lord,
appearing, আপনি কপি দিন ওনাকে, আমি নেক্সট উইকে রেখে দিচ্ছি।
হ্যাঁ নেক্সট
উইকে রাখছি, আপনি কপি দিন ওনাকে।
হ্যাঁ দিয়ে দিচ্ছি, আজকেই দিয়ে দিচ্ছি। লর্ডশিপ, আর একটা ব্যাপার আছে এখানে। লর্ডশিপ, ব্যাংক
they have already filed this.
Madam, allow him to submit, yes.
Yes.
আমি একটা দুটো আইএ আছে, এই দুটো অ্যাপিল আছে। একটা হচ্ছে অ্যাপিল 12/2024, যার এগেনস্টে অলরেডি জাস্টিস অনন্যা বন্দ্যোপাধ্যায়ের ঘরে একটা ম্যাটার চলছে, CO 678/2025-4। আর একটা আছে অ্যাপিল যেটা পার্টলি অ্যালাউ করেছেন অনারেবল ডিআরএটি, সেটা অ্যাপিল 52 of 2024, পেজ 70। তো
আপনি কপি দিন, আমি নেক্সট উইকে রাখছি।
তার এগেনস্টে ব্যাংক একটা আলাদা করে সিও ফাইল করেছে, দুটো যদি অ্যানালগাস করে করা যায়। এই যে এটা দিন, এটা থেকে তার কপিও আমাকে দেয়নি।
Yes, madam, do you have any instructions? The bank has filed this.
CO 892
Rudra Bhattacharya has filed.
এটা তো আমি করেছি, নিচে দেখুন
Already pending before the learned chief
CO 892.
892 এটা রয়েছে।
CO 892 has been filed by the bank.
Yes, yes, ma'am.
Where it is pending.
Oh, my lord.
Lordship,
it is appearing in the list before any honorable judge.
No, my lord, they are challenging the DRT order, my lord. Already pending before the justice is Bandhana Upadhyay, my lord.
প্লিজ একটু চুপ করুন।
আচ্ছা, আপনি ওনাকে কপিটা দিন, আমি নেক্সট উইকে রাখছি, তারপর দেখছি
লর্ডশিপ,
রিলেটেড
একটা ব্যাপার আছে এখানে, দুটো অ্যাপিল আছে, একটা ডিসমিস করেছে, সেই ডিসমিসের উপর তো আর হবে না।
দেখছি, আপনি কপিটা দিন,
তারপর আইএ 402 যেটা দেখে
আপনি কপিটা দিন, আমি নেক্সট উইকে রাখছি।
আমাকেও আর একটা কপি দিতে বলুন, তাহলে দুটো একসাথে।
আমি কি ম্যাটার জানি না, এখন বলতে পারছি না, আগে আপনি এটাকে কপি দিন, তারপর দেখছি। Under the same heading করে দেবেন। Next.
My lord, I am appealing on behalf of the petition.
Petitioner.
Petitioner, sir. There is no caveat. But there is no caveat.
Yes.
Thank you. My lord, the opposite party, plaintiff.
47 rejected.
My lord. My lord.
What is the number of 47? First 47, second 47.
Section 47.
How many 47?
Section 47.
Section 47, I understand. How many section 47 applications have been filed? That is what I am asking. This is the first 47?
Yes, yes.
What is the ground in 47?
There is no boundary wall. There is no identification for, there is no boundary wall in this.
There is no identification.
There is no boundary wall in the.
So you be rest assured, if there is no, cannot be identified, bailiff will go and return submitting that report.
My lord, kindly, the matter is fixed on 27th for the 27th for execution.
If there is property cannot be identified, bailiff will go and submit a report that the property cannot be. Let us see the bailiff report first.
My lord, my 47 application rejected. Kindly, I am praying for
Nothing.
some protection. My lord, interim protection. Kindly see my prayer. My lord,
What is the decree for?
Declaration and injunction. My lord,
Declaration and injunction.
Mandatory injunction. My lord,
Mandatory injunction. Say so.
And my lord, the civil judge junior division Chinsura court has dismissed the application of the plaintiff on contest. Thereafter, they have preferred an appeal. An appeal had been allowed. There was subsequently we have filed a second appeal before the honorable court, and this said is still pending. My lord, in the meantime, sections 47 application has been rejected by the landed court below. My lord, kindly please trouble to turn the application, my lord, in my application, page 85. My lord, internal page 85, 86, my lord.
Show me the decree of mandatory injunction.
Yes, my lord.
What was the direction passed?
$75, my lord.
75.
70, page number 75, my lord.
Demolish the boundary wall.
Yes, my lord.
Yes.
My lord, the paragraph 2, my lord. The defendant.
You say that the boundary wall cannot be identified.
Nowhere in the plain the boundary was not there, my lord.
So if there is no boundary wall, it will not be demolished.
My lord, kindly give me some protection, otherwise suffer
What protection?
There
was the direction to demolish the boundary wall. I accept your submission. There is no boundary wall. Bailiff will go and submit a report that there is no boundary wall.
Kindly give me some protection, my lord. Otherwise,
What protection?
Kindly,
you are fully protected by the decree. There is no boundary wall. It's an infractious decree.
There is in the plain.
According to you, it's an infractious decree. There is no boundary wall.
There is no boundary wall in the schedule of the plain.
Yes. So nothing can be demolished.
My lord, kindly.
Can anything be demolished which is not in existence?
Yes, my lord. I have apprehended, my lord. Seriously apprehended that the landed court will execute the order. Seriously, kindly give me some protection, my lord. As
what protection?
Interim state.
I can give you protection if you undertake to demolish. Give me that undertaking that you will demolish. I will give you that time.
My lord, second appeal has been pending, my lord, before the honorable court, my lord.
Obtain an order of stay. Nobody is stopping you to obtain an order of stay. That cannot be a ground for allowing section 47. Obtain a stay from the honorable division bench or the single
bench. My matter has been fixed on 27. Kindly give me some protection, my lord.
No. Obtain a 25th.
27, my lord.
27th.
My lord.
It's at the order 41 stage, second appeal.
No. My lord, the execution degree. Execution.
You have said second appeal is pending.
Before the honorable court, Honorable Justice Bivas Ranjan Dev.
That is hearing stage.
That is admission stage.
Admission second single bench. Unheard of.
No. Section 5. Only section 5 has been admitted. Only section.
Second appeal with section 5. So there is no appeal in the eye of law.
Praying before your lordship, kindly give me some protection.
No.
Otherwise, I will suffer great loss.
liberty, I will give you some time. But provided you file an affidavit of undertaking, you on your own will demolish that. Take instructions, come at before 3:25, I will give you that liberty. Make a phone call to your client. If he is ready and willing to give that undertaking, yes, I will pass an order of stay. Yes, call the next matter.
Lord, in this matter,
Yes, my lord. I'm appearing on behalf of the respondent. My lord, I'm paying for only not today, my lord.
my lord,
Mr. Jha has appeared in the
submission before your lordship.
my lord, Mr. Jha has appeared on the earlier day. He has requested my lord.
Matter
that-
was not called on, just learned advocate moved the
Yes,
court. My lord, there is a
Tomorrow,
Time.
my lord, kindly
one day,
make it updated, madam.
clearly at the top. If you want, it can be above. Ashun, the learned advocate for the petitioner is
May it please your lordship.
Appearing on behalf of the
There's a
opposite
caveat,
party.
therefore I'm
yes.
My lord, in a section 24 application of Hindu Marriage Act, a quantum of maintenance to the tune of 10,000 was passed in favor of the wife. My lord, I am for the husband. My lord, the order
You want
starts from-
reduction.
My lord,
You want reduction.
my lord, reduction as a set aside of this order, my lord.
10,000 according to you is
My lord, the woman is earning and holding opulent cars also, my lord. The woman is earning, my lord.
earning.
My lord.
Show me that this how it has been dealt with by the learned trial judge.
My lord, kindly take up page number 48.
48. No. From the impugned order.
My lord,
What is
impugned
the
order starts from page number 44.
Impugned order 44.
Annex the impugned order in the repetition previous.
My lord, that is a photocopy. The actual we have given in the certified copy also.
Yes. Where is the certified copy?
Yes.
No, my lord.
4th of December 2024.
My lord.
Yes. Yes.
My lord, we have made our submissions over there. My lord, more importantly, she has filed two assets and liability. There is a contradiction in both of them. One has been not pressed also. My lord, in that not press application, she has clarified that she is earning 20,000 per month and having a beautiful parlor in a opulent place. দাঁড়াও।
Yes, madam. Where is the finding with regard to your income? The learned judge accepts that you are earning.
My lord.
Where is that consideration?
There is in the
So-
impugned order, it is not there, my lord, but they have not paid anything and I am earning.
That is the finding.
Yes, my lord.
Madam, you have not challenged this order.
No.
So-
Previously there is a parlor is there, my lord, but subsequently it was a rent. Subsequently it was closed and presently he is.
That is not the finding.
My lord, that is not tendered in the
Kindly
evidence.
come to the last page of the impugned order. Submissions of the wife is that your submission was recorded.
My lord.
She is working in such and such, and at the same time earning of an educated and person of good health is also considered. So you're earning at the same time submission on the point that the wife is reasonably good earning is also considered in a prima facie main point to be considered whether the petitioner has sufficient means. What has been decided? Your income has not been considered.
My
What
lord.
is your income? Nothing.
My lord, in page number 40 it is a trade license.
My lord, the previously there is a parlor. It is admitted fact, my lord. Subsequently, it was closed, and presently she is.
That is not the finding. That is your submission. That is not the finding.
Return back to the trial court, my lord, and considered everything to
Yes.
their asset, and they have not filed any ITR in their asset also. in the appeal.
My lord, one more point, my lord.
What more?
Kindly take up their petition, my lord. There is no sufficient prayer also.
This court to decide the quantum of alimony.
My lord. My lord, there is on a tendency of execution also.
Court to decide the quantum of alimony.
No, my lord.
You want to take that risk?
No, my lord.
Execution.
My lord, an execution has also been filed to this effect.
If it is set aside, what execution? Execution of this or from the criminal proceeding?
My lord, from this only.
This is only the maintenance order.
Ashok.
2 minutes. Well, this matter will not take more than 2 minutes, my lord.
Not more than 2 minutes.
My lord, there is a peculiar.
So Bandhavata, you are opposing him.
My lord, I am before my lord with a very innocuous prayer, but in these circumstances, I had to approach your lordship. Lordship, what has happened? A decree was passed in 1978. Execution was passed in 1986. Decree was put into execution and the third parties were evicted in 2022.
Order 39, Rule 1 and 2 is to be heard.
My lord, it has not been recorded in the order sheet. My lord, if my application was filed way back in 2022.
No date has been fixed.
No, it was lying.
40 Rule 1.
Nothing. My lord will kindly see, this is the irony, and the entire, and they have not even given it a consideration. My lord will kindly come to the order sheet, which starts at page. My lord will kindly come.
Can you come tomorrow?
Lordship, I shall. My lord, not, and this is.
Which court?
My lord, is the second court, my lord.
Of Alipur?
My lord, no, my lord. Shialda, my lord. I'm
all right.
My lord will kindly bear. And my lord, this is a.
So according to you, Order 39, Rule 1 and 2, Order 40, no dates have been fixed.
No, my lord, civil rules and orders have been shown.
List this matter tomorrow under the same
first
heading.
civil judge. My lord, actually.
Lord, I am opposing this.
But this rises out of a matrimonial suit, not suit for divorce, counterclaim for restitution.
Can it be concluded within 2 minutes?
I'll just give your lordship that 2 minutes worth, and it won't be finished in 2 minutes, but I'll just give your lordship the fact. Now, trial is underway.
Because there is a full court reference.
Yes, I am not keep it on.
Otherwise,
take it on the next day.
All right, what is the matter?
The matter is not in the middle of trial. Suddenly, not in the middle of evidence, list of 7 witnesses given by us. The learned judge, after taking evidence of 2 from that list, says, I close the trial, close the evidence. Now you start with your argument. And the main witnesses have not been examined.
No,
nothing
not
remains
that.
of my suit. Can't be
Although
done.
it is very simple.
Can't be done. I'll show
No,
you,
it's
lordship.
not that simple, Miller.
Of course it's
Despite,
not.
Yes.
Of course it's not.
Despite the trial was not concluded because of the dragging of the matter by
I'll
the
show.
petitioner.
There's an order.
I will
There's an
also
order of this court
also
saying dragging is
we will
by them.
also show.
There's an order by
We
this
will also
court.
show.
Dragging on is by them.
13 days examination of a witness.
They have examined my witness.
13
Please
days
see how many days they've examined my
And during
witness.
the examination,
24
the
days.
witness is becoming ill.
They've examined my
total
of 31 days. They've examined my witness.
know,
So when I examine him, there's a problem.
We'll show
The last 2 witnesses we examined one day.
the order.
Anyway,
review.
but I'll go into
It is
it.
very clear.
Tomorrow it will be convenient to both of you.
Day after tomorrow. Tomorrow I have.
Day
Tomorrow I'll not.
Day after tomorrow.
Tomorrow going to copy fixed. Alipur.
Friday.
Friday.
Yes, Mr. Bachawat, Friday.
But Friday, I have a problem. There's a matter. I'm not a special bench reference on Friday. It's a little uncertain. That's all. But the trial, arguments have been asked to start off on Monday.
Yes.
On
They have
Monday,
started already
24th.
begun.
24th.
3 days they have argued the matter, my lord.
No.
3 days they have argued.
No. My learned friend is.
Tomorrow you have difficulty.
No.
No. I have.
Tomorrow you have.
I said that in that matter. Tomorrow I will not do it. Day after tomorrow in the morning I can do it.
But day after tomorrow morning,
At 2 p.m. At 2 p.m.
Yes, 2 p.m. should be all right. Not because
It will appear just after the fresh motions.
Very well.
But at 2 p.m.
But if there's some difficulty, my learned friends will be there.
No, I will. At 2 p.m. At 2 p.m. That
But
matter
if-
has been fixed.
Well,
At 2
no,
p.m.
keep it on Friday. If there's some difficulty, my lord, your lordship will keep it on Monday in that case with some prep.
But you said Monday is the date fixed for
But we'll do it
argument.
in the morning. We'll do it in the morning, lord. Monday morning.
Monday, Mr.
Monday
Bachawat,
morning at-
after, because the fresh motions are to be given priority. After that, this can come.
I don't know special bench to on hobby. That's all. My lord, keep it at 2 p.m. on Friday. No difficulty. Keep it.
Mr. Bachawat, learned senior advocate,
No, there is a